You want to sit in my courtroom, you stand like everybody else, or I'll have you removed in cuffs." The words hit the gallery like a slap. Row after row of faces went still. A woman in the second bench covered her mouth. The court reporter's fingers froze mid-keystroke. The woman standing at the defendant's podium didn't flinch. She gripped the wooden rail with both hands, weight shifted entirely to her right leg, left knee visibly swollen beneath dark slacks. A metal cane leaned against the rail beside her. Scuffed aluminum, VA issued, the rubber tip worn smooth from years of use. She said nothing, just looked up at the man in the black robe and held his gaze for 3 full seconds. Judge Caldwell Briggs had just threatened a disabled veteran with handcuffs for requesting a chair, and that veteran had a recording device in her jacket pocket that had been running since 6 that morning. He didn't know that. He didn't know anything about her. Not where she'd served, not what she'd survived, not who she worked for, not what she'd been documenting for the past 3 weeks in a small leather notebook that never left her side. He only knew what he saw. A black woman with a limp and a $20 parking ticket who didn't know her place in Carver County. He was about to learn how wrong he was. But not today. Not yet. First, she had to let him finish what he'd started, because the more he did, the more she recorded, and the more he recorded, the less he'd have when the time came to answer for it. She adjusted her grip on the rail. The cane slid an inch, tapped the floor. The sound echoed in the silence like a gunshot nobody wanted to acknowledge. And across the courtroom, mounted high on the back wall where nobody ever looked, a small brass plaque read, "All persons with disabilities are entitled to reasonable accommodations, pursuant to 42 U.S.C., Section 12132. The plaque was dusty. Nobody had read it in years. Until her. If this satisfies your curiosity, subscribe now, because what this judge does next will make your blood boil. 3 weeks earlier, Nadine Okafor woke at 4:58 a.m. in room 14 of the Pinecrest Motor Lodge, 2 minutes before her alarm. She didn't need it. Hadn't needed an alarm in 11 years. Not since Kandahar, not since the IED that took most of her left kneecap and all of her trust in predictable mornings. The room was cheap. Thin walls, a window unit that rattled, a mattress that sagged in the center like a hammock. But the sheets were clean and the door had a deadbolt that actually worked, which was more than some places she'd stayed. She sat up slowly. Left knee first, always the left knee first, rotating it in small circles, testing the range before putting weight on it. The joint popped twice. Pain bloomed, familiar and dull, a thing she'd stopped fighting years ago and started managing instead. Her shoes sat aligned at the foot of the bed, laces tucked inside, toes pointing toward the door. The cane leaned against the nightstand on her right, always the right side, always within arm's reach, always in the same position. Muscle memory. If she had to move fast in the dark, her hand would find it without searching. She stood, limped to the bathroom, ran the water until it was warm enough, then washed her face, brushed her teeth, took 2 ibuprofen with a cupped palm of tap water. The orange prescription bottle on the sink, tramadol for the bad days, she left untouched. Today needed clarity, not comfort. Back in the room, she dressed in layers. Dark slacks, white blouse, a charcoal blazer that was professional without being expensive. She checked her bag the way she checked it every morning. Folder of documents on top, leather notebook second, 2 pens clipped to the notebook's spine, water bottle in the side pocket, phone in the inner zip. She counted each item with her fingers, touching them in sequence. Nothing missing, nothing out of order. The routine was automatic, the kind of discipline that came from environments where forgetting one piece of equipment could cost more than inconvenience. She slipped the blazer on. In the left interior pocket, sewn into the lining near the second button, a device no larger than a shirt button sat flush against the fabric. It looked like a spare fastener. It was not. She pressed it once. A faint vibration confirmed activation. 8 hours of battery. Omnidirectional microphone. 64 gigabytes of storage. Nadine locked the motel room, crossed the gravel lot to her rented sedan, a gray Nissan, forgettable, and drove east on Route 9 toward Carver County Courthouse. The courthouse sat on the town square like a wedding cake left in the rain. White columns, Georgian brick, a flagpole out front with the state flag snapping in the October wind. Built in 1954, renovated in 1987, and largely ignored since. The parking lot had 62 spaces. 2 were marked with the blue wheelchair symbol, both near the front entrance. Both were occupied by vehicles without disability placards. Nadine pulled into the lot at 7:41 a.m. She noted the 2 illegally parked vehicles, a white Ford F-150 plate number GCH4419 and a silver Dodge Charger, plate GBR7102. She wrote both in her notebook, along with the time, the date, and the weather. Clear sky, 58 degrees, light wind from the southeast. She parked 3 rows back, the closest available space. 212 steps to the front entrance, give or take. She'd counted them on her first visit. Walking that distance took her 4 minutes on a good day, 6 on a bad one. Today was middling. The knee was stiff but functional, the ibuprofen starting to soften the edges. The front entrance had 7 steps. No ramp. She climbed them one at a time, cane in her right hand, left hand gripping the iron rail that was loose in its mounting and wobbled with each pull. By the top step her breathing was audible and sweat had broken across her forehead despite the cool air. Inside, the lobby smelled like floor wax and old paper. A metal detector stood between 2 columns, flanked by a conveyor belt for bags. Behind the checkpoint, a man in a deputy's uniform sat on a stool scrolling his phone. Rowan Scaife, 6'2", broad shoulders, buzz cut going gray at the temples. Court security officer for 11 years. He looked up when Nadine approached, and his expression shifted. Not hostile exactly, but assessing. The kind of look that measured a person's right to be somewhere before they'd said a word. Bag on the belt. Step through. She placed her bag on the conveyor, stepped toward the metal detector. The cane triggered it immediately. A sharp, insistent beep that echoed off the marble floor. Hold on. Scaife slid off the stool, producing a handheld wand. Arms out. She extended her arms. He waved the wand, quickly, perfunctorily, barely pausing at her midsection. Then he pointed at the cane. That too. It's a medical device. It's metal in a courthouse. He held out his hand. Let me see it. She handed him the cane. He examined it the way someone examines a thing they've already decided is suspicious. Turning it over, rapping his knuckle against the shaft, peering at the rubber grip as if contraband might be hidden inside. I'll need it back to walk to the courtroom, she said. Even, not pleading, just factual. Scaife held the cane a beat longer than necessary. 3 seconds, maybe 4, before extending it back to her, but he didn't hand it. He held it at arm's length, low, so she had to reach down and forward to take it. The motion pulled her off balance. Her left knee buckled slightly. She caught herself on the conveyor belt's edge, knuckles white. He watched her steady herself. Didn't offer a hand. Didn't step closer. Just watched, the way someone watches a thing that doesn't interest them enough to help, but interests them enough to observe. Courtroom B is up the stairs, end of the hall. She looked past him. A wide staircase led to the second floor. 16 steps, no elevator sign visible, no ramp, no lift. Is there an elevator? Out of order. He said it without looking up, already back on his stool, already back on his phone. Been out of order since June. 4 months. The elevator had been broken for 4 months in a public courthouse that served a county of 43,000 people, and nobody had fixed it, and nobody had posted an alternative, and nobody seemed to think this was a problem. Nadine looked at the stairs, looked at her cane, looked at the brass plaque mounted on the wall beside the metal detector, the one about reasonable accommodations, the one quoting federal law, the one covered in a fine layer of dust that suggested it hadn't been cleaned since it was hung. She opened her notebook, wrote, "No ramp front entrance, no elevator operational. A DA plaque present, but facility non-compliant. SCAFE, delayed return of mobility device. Then she closed the notebook, tucked it into her jacket, and started climbing. In the second-floor hallway, a row of wooden benches lined the wall outside courtroom B. Half were occupied. People waiting for traffic court, small claims, the minor machinery of county justice. An older man in a Veterans of Foreign Wars cap sat at the far end, hands folded in his lap, right leg bouncing with a tremor he couldn't control. Nadine lowered herself onto the bench beside him. The wood was hard, the seat too narrow, the back angled wrong. She positioned her cane between her knees, both hands resting on the grip, and exhaled slowly through her nose. The man glanced over. Mid-50s, deep brown skin, a scar running from his left ear to his jawline. He wore a pressed flannel shirt and work boots that had been polished recently. "First time with Briggs?" She looked at him. "Excuse me?" "Judge Briggs." He nodded toward the courtroom door. "You here for traffic court?" "Expired meter." He almost smiled. Almost. "Me too. Well, not the meter. Parking violation. My disability placard expired, and the VA hasn't sent the renewal. 3 weeks now." "How long ago was the ticket?" 6 weeks. I called the VA 4 times. They said it's processing." He extended a hand, the one that wasn't trembling. "Terrell Boone, 82nd Airborne, retired." She shook it. "Nadine Okafor." "You serve?" "Once, long time ago." He nodded, recognizing the deflection of someone who didn't discuss their service casually and didn't push. Instead, he leaned closer, dropped his voice. "Listen, Briggs doesn't do accommodations. I asked for a chair last time because my leg was bad. He said if I could walk in, I could stand up. Exact words." She was quiet for a moment. Then, "They should have a procedure for this. Every facility like this is supposed to file a report with the state." Terrell looked at her, a beat longer than casual. The words were generic, but the way she said them wasn't. Precise, weighted, like someone who knew exactly what she was referencing but chose not to specify. Before he could respond, the courtroom door opened and a voice called the next case number. A woman appeared in the doorway, mid-40s, blonde hair pulled into a tight French twist, charcoal pantsuit, reading glasses perched on her nose. Meredith Lyle, court administrator, Carver County. Her smile was the practiced kind, wide enough to appear friendly, shallow enough to mean nothing. "All parties for the 9 a.m. docket. Please come inside." Nadine stood. The motion took effort, pushing off the bench with both arms, shifting weight to the cane, straightening her left leg in increments. Meredith watched from the doorway, smile unchanged. "Ma'am, is there an accessible entrance to the courtroom? I notice the main door has steps." Meredith's smile didn't waver. "We're renovating, sweetie. Should be done by spring." "Maybe." Spring was 6 months away. The ADA didn't say eventually. It said, now. Nadine walked through the door, 4 steps down into the courtroom, because the room sat lower than the hallway, an architectural quirk that required everyone to descend a small set of stairs to reach the gallery seating. No rail on either side, no ramp, no alternative. She took the first step. The cane slipped on the stone edge, a sharp scrape that drew eyes from the front row. She caught herself, hand slamming against the doorframe. Her knee screamed. She took a breath. Second step. Third. Fourth. A man in the gallery, white-haired, wearing a bolo tie, half rose from his seat, reaching toward her arm. "No physical contact in the courtroom, Mr. Garrett," Rowan Scaife's voice, from somewhere behind her. He'd followed her up, or he'd been waiting. Either way, the man sat back down, and Nadine completed the descent alone. She found a seat in the third row. The wooden bench was identical to the ones in the hallway, hard, narrow, angled wrong. She sat, positioned the cane, and opened her notebook. Courtroom B was rectangular, low-ceilinged, lit by fluorescent tubes that hummed at a frequency just high enough to notice. The judge's bench sat on a raised platform at the front, flanked by the state and county flags. Behind the bench, on the wood-paneled wall, a brass plaque. In this courtroom, all persons shall be treated with dignity and respect under the law. Below it, a smaller sign. Reasonable accommodations will be provided upon request, pursuant to the Americans with Disabilities Act, 42 U.S.C. Section 12132. Nadine read the sign, wrote its exact text in her notebook, underlined the word provided. Then she looked at the courtroom around her. No wheelchair spaces in the gallery, no assistive listening devices, no large print signage, and underlined the word a second time. A side door opened. Judge Caldwell Briggs entered. He was smaller than she'd expected, 5'8", maybe 5'9", thin-shouldered, with a receding hairline he'd combed carefully to disguise. Wire-rimmed glasses sat on a narrow nose. His robe was pressed, his collar starched, his shoes polished to a shine she could see from 3 rows back. Everything about him was precise, controlled, deliberate, the presentation of a man who compensated for physical stature with the performance of authority. He settled into his chair, adjusted his microphone, shuffled papers. All rise. The bailiff's voice, a thick man in his 40s named Nolan Gist, crew-cut, neck wider than his jaw, echoed through the room. Everyone stood. Nadine stood. The motion was slow, visible, painful. She gripped the bench in front of her with one hand and the cane with the other, pulling herself upright inch by inch, while the rest of the gallery rose and sat in a single fluid motion. Briggs didn't notice, or didn't care. He was reading something on his desk, pen tapping a rhythm only he could hear. The first 3 cases were fast. Speeding ticket. Guilty, $100 fine. Failure to yield. Guilty, $60 plus court costs. Expired registration. Continued to next month pending proof of renewal. Briggs moved through them like a machine. No eye contact with defendants. No questions beyond, how do you plead? No acknowledgement that the people standing before him were anything other than items on a list. Then, case number 2025-TR-4471, Okafor. Nadine stood. Again, the slow process, the cane, the visible effort. She made her way to the podium at the front of the courtroom, 8 steps from the bench, each one deliberate. She reached the podium, gripped the rail, looked up. Briggs was reading the file. He hadn't looked at her yet. Expired meter violation, downtown lot, September 28th. How do you plead? Your Honor, before I enter a plea, I'd like to request a reasonable accommodation. He looked up. First time. His eyes moved from her face to the cane, then back. What kind of accommodation? Permission to sit, Your Honor. I have a service-connected disability that makes prolonged standing painful and medically inadvisable. Something shifted in his expression. Not sympathy, irritation. The particular irritation of a man who viewed any deviation from his routine as a personal challenge to his authority. Everyone stands in my courtroom. Equal treatment. She kept her voice level. Your Honor, I'm reading from the sign posted on your wall. Reasonable accommodations will be provided upon request, pursuant to the Americans with Disabilities Act, 42 U.S.C. Section 12132. I'm making that request now. Permission to sit. The gallery went quiet, not the usual courtroom silence, something tighter, more alert, people leaning forward, the court reporter's fingers hovering. Briggs stared at her for a long moment. Then he said very slowly, very clearly, as if explaining something to a child who refused to learn. Denied. You walked in here on your own 2 feet. If you can walk, you can stand. He looked back down at his file. Conversation over. Next item on the list. But Nadine didn't move, didn't speak, didn't argue. She shifted her weight to the cane, adjusted her grip on the rail, and stood. Her left knee burned. The ibuprofen was wearing off. She could feel the joint swelling inside the brace she wore beneath her slacks. a rigid plastic shell that held the kneecap in alignment but did nothing for the pain that radiated upward through her thigh and downward into her calf like electricity running through wet wire. A D.A. Clint Mosser rose from the prosecution table. Mid-30s, narrow face, suit jacket too tight across the shoulders. He carried a manila folder with colored tabs, organized, prepared, the posture of a man who enjoyed the mechanics of conviction. Your Honor, the state notes that Ms. Okafor has 2 prior parking violations on record. Nadine looked at him. Those were issued in Fulton County. Different jurisdiction. They're not relevant to a Carver County citation. Mosser didn't acknowledge her. He addressed the bench. The state recommends the standard fine be doubled to reflect the defendant's pattern of non-compliance. Your Honor, Nadine began. The fine is doubled. Briggs didn't look up. $240, pay at the clerk's window, next case. She stood there for a moment. Processing. Not the fine. The fine was irrelevant, but the speed of it. The casual efficiency with which a judge could deny a disabled person's legal right to accommodation, allow a prosecutor to cite irrelevant prior offenses from another jurisdiction, double a penalty without discussion, and move to the next file in under 4 minutes. She wrote 3 words in her notebook. Pattern, documented, continuing. Then she turned, limped back to her seat, collected her bag, and climbed the 4 steps out of the courtroom. Each step harder than the one before. Each step watched by Nolan Gist, who stood at the door with his arms folded and his expression blank and didn't offer to help and didn't step aside to give her more room and didn't do anything at all except exist as an obstacle she had to navigate around. In the hallway, Terrell Boone was waiting. He'd been called before her and was already done. Another fine, another denial. How'd it go? He asked. About how you described. Doubled the fine? She nodded. Terrell exhaled through his teeth. He does that, every time, especially if you push back. He doubled mine, too. $300 for an expired placard that the VA hasn't renewed. They walked toward the staircase together. Slowly. 2 veterans descending 16 steps in a courthouse that had no working elevator and no ramp, and a security officer who treated mobility devices like contraband. You know a man named Deshaun Niles? Terrell asked when they reached the lobby. No. Purple heart, titanium hip. He was here 2 months ago, same courtroom, same judge. Asked for a chair. Briggs told him to stand or leave. Niles couldn't do either. His hip locked up. He grabbed the podium to keep from falling. Briggs called it disrupting proceedings and held him in contempt. 48 hours in county lockup. Nadine stopped walking. 48 hours. For a man with a titanium hip, for sitting down. For not standing up. Terrell's voice was flat. The voice of a man who'd stopped being surprised and started being tired. Nobody filed anything. Nobody reported it. Niles doesn't have the money for a lawyer, and legal aid told him contempt findings are discretionary and hard to appeal. They stood in the lobby, 2 people with service-connected injuries, in a building that quoted federal disability law on its walls and violated it in every hallway and doorway and staircase. Terrell, she said. How many others? He looked at her. Careful now, measuring. I know 3 personally. All vets, all disabled, all fined or held in contempt by Briggs for things that wouldn't have happened if the courthouse followed the law. 2 black, 1 Latino. All of them had their accommodations denied. She opened her notebook, wrote the names he gave her, wrote Niles's story, wrote the details, dates, fines, outcomes. Terrell watched her write with the focus of a woman who'd done this before, who had a system, who treated information the way soldiers treat ammunition. Carefully, precisely, knowing it mattered. You some kind of reporter? He asked. No. Lawyer? No. He waited. She didn't elaborate. He nodded, accepting the non-answer the way veterans accept classified information, which is to say completely, because some things aren't yours to know until someone decides they are. She thanked him. He gave her his phone number, written on the back of a VA appointment card, the ink smudged, The card creased from weeks in a wallet. She put it in her notebook and left through the front entrance, down the 7 steps, across the lot to her gray Nissan. She didn't drive to the motel. She drove past it, turned left on Route 9, and pulled into the parking lot of a single-story brick building set back from the road behind a row of Bradford pear trees. No sign on the door, no flag. One security camera above the entrance, lens aimed at the parking lot. She went inside. The door closed behind her. The lock clicked twice. 3 days later, Nadine returned to Carver County Courthouse, this time for the appeal. She'd filed the paperwork the day after her hearing. A standard appeal of a traffic fine, nothing unusual, nothing that would draw attention. The form was available online, which was how she'd gotten it, because when she'd asked Meredith Lyle for a copy in person at the clerk's window, Meredith had looked at her with the practiced blankness of bureaucratic obstruction and said, "I'm not sure we have those in stock. Can you come back Thursday?" Thursday was 4 days away. The filing deadline was 3. So Nadine had downloaded the form, completed it, and submitted it by mail with a tracking number and a return receipt. The confirmation arrived 2 days later. Hearing date, October 20th, 9 a.m., Courtroom B. Judge Briggs presiding. But first she had a different errand. The clerk's office on the first floor handled ADA complaints, or was supposed to. A laminated sign in the lobby listed the process. Persons requesting disability accommodations or wishing to file an ADA grievance may obtain Form 504 at the clerk's window. Nadine approached the window. Meredith Lyle stood behind it, sorting files with the unhurried efficiency of someone who controlled access to paperwork and enjoyed the power that came with it. "Good morning. I'd like a Form 504, please." Meredith looked up. Recognition. The smile returned. Wider now, with something behind it. Not warmth, awareness. "Form 504, let me check." She turned to a filing cabinet. Opened a drawer. Closed it. Opened another. Closed it. Moved to a second cabinet. Repeated the process. The performance took 90 seconds and communicated a clear message. "Your needs are not my priority. I'm sorry, I don't seem to have any in stock. We can order more, 6 to 8 weeks usually. The form is mandated by 28 CFR Section 35.106. Every public entity receiving federal funds is required to have it available." Meredith's smile thinned. Not much, just enough to show the edge underneath. "I understand your frustration, hun, but I can only give you what we have, and we don't have any right now." Nadine reached into her bag, pulled out a printed copy of Form 504, downloaded from the Department of Justice website that morning, filled out in neat block letters, every field completed. "I brought my own. I'd like it date-stamped and filed, please." Meredith took the form, read it slowly. Her eyes paused on the section marked Nature of Complaint. Denial of reasonable accommodation. Request to sit during court proceedings denied by presiding judge, October 17, 2025, case number 2025-TR-4471. I'll need to have the compliance officer review this before I can file it. Who is the compliance officer? Pause. I'd have to check. I'll wait. Meredith's jaw tightened. She picked up the phone, dialed an extension, waited. Put the phone down. He's not available today. I'll leave a message. I'd like his name, please. I'm not authorized to give out staff contact information. It's a public position. The ADA coordinator's name and contact must be publicly available under the same regulation I just cited. Silence. The kind that fills a space when someone is deciding whether to cooperate or escalate. Meredith chose a third option. She stamped the form with the date, placed it in a tray marked General Correspondence, and slid the receipt across the counter. Not the ADA tracking system, not the federal compliance log. General Correspondence. The bureaucratic equivalent of a trash can with a nicer label. Nadine saw which tray. She noted it in her notebook. Date, time, tray designation, Meredith's name badge number, CCC-0147. Thank you, Ms. Lyle. Already sorting the next stack. Already done with her. Check. If you think this is outrageous, wait until you hear what they do to her complaint, and to the 3 others they erased from existence. Stay with me. Nadine spent the next 6 days doing what she did best. Observing, documenting, mapping. She came to the courthouse every morning at 8 a.m., sat in the lobby, in the hallway, in the gallery of courtroom B during open sessions. She watched Briggs handle cases. She watched how he treated people who asked for accommodations. Not just disabled people, but anyone who needed something that deviated from his routine. An elderly man who needed a bathroom break during testimony, denied. A woman with a hearing aid who asked the witness to speak up, told to pay better attention. A father holding an infant who needed to step out when the baby cried, informed that disruptions would be noted on his file. But the pattern was sharpest with disabilities, and sharpest of all with disabled veterans, and sharpest of all with disabled veterans who were Black. She recorded the data, names, dates, case numbers, outcomes. She cross-referenced with public records, PACER filings, county court dockets, VA correspondence that Terrell Boone and 2 other veterans gave her copies of. She built a spreadsheet on her laptop at the motel each night, color-coded by type of violation, severity, demographic. 14 ADA complaints filed in 3 years. 44 additional accommodation requests logged and denied in court transcripts. 3 complaints that had been filed but no longer existed in any county database. She found this last detail on day 5 when she requested the complaint log through a FOIA request submitted to the county clerk's office. The response came back within 48 hours, unusually fast, which meant someone wanted her to see the numbers and be satisfied by them. The log showed 11 complaints. Her own made 12. But Terrell had given her copies of 3 complaints filed by veterans, his own, Deshaun Niles's, and a man named Corporal Arturo Reyes, who'd been denied a sign language interpreter for his deaf wife during a custody hearing. All 3 had receipts, date-stamped forms, tracking numbers, confirmation letters. None of the 3 appeared in the county's log. 3 complaints, filed, confirmed, then erased. Nadine wrote the discrepancy in her notebook, drew a box around it, then drew a second box. On October 20th, she went back for her appeal hearing. The courthouse was the same. The steps, the metal detector, Scaife on his stool, scrolling, the broken elevator, the stairs. But this time, something was different. When she reached the security checkpoint, Scaife looked up with an expression she hadn't seen before. Not the casual assessment of her first visit, but something sharper. He'd been told about her. She could see it in the way his posture changed. Straighter, wider, the body language of a man positioning himself as a barrier rather than a checkpoint. Bag on the belt, cane on the belt. The cane is a medical on the belt. She placed the cane on the conveyor. It rolled through the X-ray machine. She stepped through the metal detector. Clean. On the other side, Scaife picked up the cane, examined it again, slowly, turning it over, tapping the shaft. Then he set it down, not on the counter where she could reach it, but on a chair behind his station, 3 feet away, and behind the checkpoint barrier. I need that to walk. You'll get it when I'm done with my inspection. You inspected it 3 days ago. It's the same cane. He didn't answer. He picked up a clipboard, made a note, set it down. Then he reached for the cane and knocked it off the chair. It clattered to the floor, the sound sharp and metallic in the marble lobby. He looked at it, looked at her. Oops. She stared at him. 3 seconds. 4. Then she walked around the checkpoint barrier, slowly, painfully, each step without the cane an exercise in controlled imbalance, bent down, picked it up, and straightened. The motion cost her. She could feel her knee grinding, bone on scar tissue, the particular agony of cartilage that no longer existed doing work it couldn't do. Her face showed nothing. Her eyes showed everything. She held the cane in her right hand and walked toward the staircase without looking back. Scaife watched her go. Then he picked up his phone and made a call. Upstairs, the hallway was crowded. More people than the last visit. It was a Monday, the heavy docket day. Nadine found a spot on the bench outside courtroom B and sat carefully, positioning her knee at the angle that hurt least. Terrell wasn't there. She'd learn later that he'd been called for a different date. His hearing rescheduled without notification. The letter arriving after the new date had already passed. Another fine, another bench warrant when he didn't appear for a hearing he didn't know about. The courtroom door opened at 9:12 a.m. 12 minutes late, Meredith Lyle stood in the doorway, clipboard in hand, reading glasses on. All parties for the 9 a.m. docket. Nadine entered. The 4 steps, the descent. No rail added, no ramp, no change. This time she held the doorframe with her left hand and the cane with her right and went down sideways, 1 step at a time, like a person navigating a ship's ladder in rough seas. It was safer. It was slower. It drew every eye in the gallery. She sat in the 3rd row. Same seat, same hard bench, same humming fluorescent lights. Briggs entered at 9:22, 22 minutes late. Nobody commented. Nobody seemed surprised. The docket moved, case after case. Briggs dispatched each one with the same mechanical efficiency. No eye contact, no questions, minimal engagement. A woman crying as she explained she couldn't pay a $500 fine on a waitress's salary. Briggs. Payment plan available at the clerk's window. Next. A teenager with his mother caught with a fake ID. Briggs. 30 days suspended, 100 hours community service. Next. Then, case number 2025-TR-4471-A. Okafor. Appeal. She stood. The slow process, the cane, the walk to the podium. Briggs looked at her this time. Immediately. He remembered. Ms. Okafor, you're appealing the fine? Yes, Your Honor, and I'm renewing my request for a reasonable accommodation, permission to sit during these proceedings. His jaw moved, a small lateral motion, like grinding. Then he leaned forward, both forearms on the bench, and spoke with the exaggerated patience of a man who believes he's being generous by not shouting. I denied that request at your last appearance. The denial stands. Do you have anything new to present on the appeal, or are we wasting the court's time? Your Honor, denying a disability accommodation request without engaging in an interactive process violates Title II of the ADA. I'm asking the court to reconsider. Denied. The word came sharp, louder than necessary, a crack of authority that made the court reporter flinch. One more word about accommodations and I will hold you in contempt. Am I clear? She looked at him, steady, level, no anger on her face, or rather anger so deep and so controlled, it read as stillness. Crystal clear, Your Honor. Good. Now, your appeal. The fine was doubled due to prior violations. Prior violations in a different jurisdiction, Your Honor. Fulton County citations aren't relevant to Carver County proceedings. There's no legal basis for the enhancement. Mosser stood. Your Honor, the state's position is that a pattern of non-compliance. Sit down, Mr. Mosser. I'll handle this. Briggs looked at Nadine. The fine stands. Appeal denied. $240 due in 30 days. Failure to pay will result in a bench warrant. Are we done? She could have argued, could have cited case law, precedent, the specific regulatory framework that prohibited exactly what he'd just done. She had the knowledge. She had the training. She had a leather notebook with 47 pages of documentation that would, in a different setting, reduce this man's career to a cautionary tale in a judicial ethics seminar. But she didn't. Not yet. Because the more he did, the more she had. And the more she had, the harder it would be for anyone to call it an isolated incident, a misunderstanding, a difference of judicial temperament. "We're done, Your Honor." She turned to walk back to her seat. "Miss Okafor." She stopped. "Next time you come to my courtroom, leave the attitude at the door." She didn't respond. She walked, slowly, painfully, the cane clicking on the floor in a rhythm that marked each step like a metronome counting down to something nobody in the room could see yet. Back to the third row, sat down, and opened her notebook. She wrote, "Appeal denied. Accommodation denied second time, with threat of contempt. No interactive process attempted. Briggs, October 20th. AD of violation number 7. 7. In 3 visits. 7 documented violations of federal disability law by a single judge in a single courtroom." And she wasn't done counting. Outside the courtroom, in the hallway, Terrell was leaning against the wall with his eyes closed. The tremor in his right hand had spread to his forearm. He opened his eyes when he heard the cane. "$450, he said. "My total now, between the first fine, the doubled fine, and whatever they'll add next." He laughed, dry, brittle, the sound a thing makes before it breaks. "I get $600 a month from disability. After rent, I've got $180 left for food, medicine, gas. They want $450. They started walking toward the stairs. Nolan Gist appeared at the end of the hallway, emerging from the courtroom with the rolling gait of a man who enjoyed the weight of his own authority. He saw them, changed direction, walked straight toward Terrell. "Mr. Boone, you've got an outstanding balance at the clerk's window. You need to handle that before you leave the building." "I just came from the courtroom. The judge gave me 60 days. "The judge gave you 60 days on the new fine. The old balance is separate. The clerk's office has a hold on your file." Terrell's face tightened. "What kind of hold?" Gist moved closer, close enough that Terrell had to look up at him, close enough that the size difference became a statement. "The kind where you don't leave until it's settled, sir." The "sir" was a weapon. The pause before it, the slight emphasis, the way it landed like a backhanded compliment, all of it calculated to remind Terrell that courtesy could be a form of condescension. Terrell took a step back. Not fear, space. The instinct of a combat veteran who understood positioning and didn't like having someone inside his perimeter. Gist stepped forward to close the gap. "Problem? I just need some room." "You've got plenty of room." Gist's hand came up, ostensibly a gesture, a pointing motion toward the clerk's window. But his forearm caught Terrell's shoulder and pushed. Not hard, not soft either. The kind of contact that exists in the gray zone between accident and intent, designed to provoke a reaction that would justify escalation. Terrell stumbled. His bad leg, the right one, the one with the tremor, buckled for a half second. He caught himself on the wall. His VFW cap fell off. It hit the tile floor upside down, the insignia facing the ceiling. Nadine watched. Her hand tightened on her cane until the knuckles went white. Gist looked down at the cap. Didn't pick it up. Stepped over it. "Clerk's window, before you leave." He walked away. Terrell stared at the wall, breathing hard, the tendons in his neck visible, his jaw locked so tight the muscles jumped. Then he bent, slowly, painfully, his right leg barely cooperating, and picked up his cap. Put it back on, straightened it with shaking hands. Nadine bent beside him. Not to help, he didn't need help, but to be at his level, to meet his eyes. "I saw that," she said. Quiet. All of it. "It doesn't matter." "It matters." He looked at her. Something flickered behind the exhaustion. Not hope exactly, but the memory of what hope had felt like before 3 years of Carver County had ground it down to powder. "Who are you, Nadine?" She held his gaze. Someone who's paying attention. They descended the stairs in silence. 16 steps, 2 veterans, 1 cane between them. The elevator still broken. The ramp still absent. The brass plaque about reasonable accommodations still dusty, still unread, still mounted on the wall like a promise nobody intended to keep. 4 days later, Nadine received a letter at the motel. No return address, just the Carver County seal and a single page of official letterhead. R.E. A.D. A complaint. Form 504. Filed October 20th, 2025. Dear Ms. Okafor, your complaint has been reviewed and determined to contain insufficient documentation to proceed. Please provide medical certification of disability from a licensed physician, including diagnosis, functional limitations, and recommended accommodations. Additionally, a copy of your Department of Veterans Affairs disability rating, if applicable, must be submitted in original form, not photocopy. Until such documentation is received, your complaint will be classified as inactive. Regards, Carver County Administrative Office. She read it twice. Then she set it on the motel desk next to the brochure she'd brought from the DOJ website, the one that stated, in plain language, that public entities could not require medical documentation when a disability was obvious, and that a VA disability card was sufficient proof of service-connected disability status. She'd submitted her VA card with the original complaint. 70% rating, service-connected. The card was in the file Meredith had stamped and placed in the general correspondence tray. They'd either lost it, ignored it, or removed it. She photographed the letter, saved it, added the date to a timeline that now stretched across 3 pages of a new notebook. This one kept at the building with no sign, not in her bag, not anywhere Scaife could reach. 1 week later. October 27th. Nadine came back. Not for her case. That was over. The fine paid. The appeal exhausted. She came as a member of the public, exercising her right to observe open court proceedings. She sat in the gallery of Courtroom B with her notebook and her cane and her blazer, with the device in the pocket, and she watched. She watched Briggs deny a wheelchair-using woman's request to approach the bench from the side aisle, because the center aisle is the only authorized path. The center aisle was 22 inches wide. The wheelchair was 24. She watched Mosser argue for enhanced penalties against a deaf man who'd missed a court date because the notification was sent by phone, voice only, no text, no email, no written letter. She watched Nolan Gist physically redirect a man with a service dog away from the courtroom entrance because animals aren't permitted, despite the dog wearing a vest, despite the ADA, despite the man's repeated, increasingly desperate explanations that a service animal is not a pet. The man's name was Curtis Vega. He was blind in his left eye, shrapnel from Fallujah, 2004, and the German Shepherd at his side was his mobility guide, trained and certified, wearing a harness with a Red Cross patch and a tag from Southeastern Guide Dogs. Gist blocked the door with his body. "Sir, you need to leave the animal outside. She's a service dog. She's trained. She's allowed under federal law." "Not in this courtroom, she's not. Judge Briggs has a policy." Curtis held up the dog's certification tag. Gist didn't look at it. Instead, he reached down and grabbed the harness strap, yanked it sideways, pulling the dog away from Curtis's leg. The shepherd yelped. Curtis stumbled, losing his anchor point, his blind side now facing the hallway wall with no reference for orientation. "Don't touch her." Curtis's voice went tight, military tight, the kind of tight that precedes either perfect discipline or explosive violence. Just let go of the harness. But the damage was done. The dog was nervous now, pressed against Curtis's leg, panting, trained not to react aggressively, but clearly stressed by the rough handling. "You can tie her up out front, or you can reschedule." Curtis stood there for a long moment. A man with one working eye and a dog that had been assaulted by a government employee standing outside a courtroom he had every right to enter, choosing between his legal rights and the reality of a bailiff who didn't care about either. He left, took the dog, walked down the stairs slowly, carefully, one hand on the rail, the other on the harness, navigating a building designed for people who could see with both eyes and walk without assistance. Nadine wrote everything down. Curtis Vega, German Shepherd, name on the vest, Ranger. Gist grabbed the harness. Time, 10:22 a.m. The dog yelped. Curtis left without attending his hearing. She wrote it all. At 11:47 a.m., during a recess, Meredith Lyle approached her in the hallway. "Ms. Okafor, can I help you with something?" "No, thank you. I'm observing." "Observing?" Meredith tilted her head. "You don't have a case on the docket today. Public proceedings are open to public observation. It's in the courthouse rules posted at the entrance." "Of course." The smile. The empty, professional, slightly threatening smile. "It's just, Judge Briggs has noticed you've been here several times. He's wondering if there's a reason." "The reason is that court proceedings are public, and I'm the public." Meredith's smile held, but her eyes moved, quickly, like a calculation being performed, from Nadine's face to her notebook to her bag to her cane and back. "Well, if you need anything, you know where to find me." She walked away. Nadine watched her go, then watched her pull out her phone in the stairwell and make a call. 30 seconds. Brief. Then Meredith pocketed the phone and descended the stairs with the brisk efficiency of someone who'd just reported to someone who'd just given an instruction. Nadine wrote, Lyle approached, questioned presence, called someone after, 30 seconds, stairwell. That evening, back at the motel, her phone buzzed, a text from an unknown number. "This is Terrell. New phone. Got rescheduled without notice. Missed hearing. Bench warrant issued. Can you help?" She called him back. He told her the story. The hearing moved forward without him. The fine tripled for failure to appear. The warrant issued that afternoon. He'd found out from a neighbor who worked at the courthouse and saw his name on the daily sheet. "Terrell, do you still have the original notice with the first hearing date?" "Yeah, got it right here." "And you never received a rescheduling notice?" "Nothing. No letter, no call, no email, nothing." She was quiet for a moment. "Hang on to that original notice. Don't lose it. Don't give it to anyone. Make a copy and keep the copy somewhere else." "Why?" "Because if they rescheduled without proper notification, the bench warrant is invalid. And if they did it deliberately, if they moved your date to prevent you from appearing, that's a different kind of problem." Terrell was quiet. Then, "Nadine, who are you?" She didn't answer the question. "I'll call you tomorrow. Don't talk to anyone at the courthouse until then." She hung up, sat on the edge of the motel bed, phone in her lap, looking at the wall. The wallpaper was peeling near the ceiling, revealing a layer of older paper underneath. A different pattern, a different era, buried and mostly hidden, but still there if you knew where to look. November 3rd. The day it escalated beyond procedure and into something physical. Nadine arrived at the courthouse at 8:35 a.m. She was there to observe, same as the previous week, same routine, same seat in the gallery. But today, the routine broke. Scaife was waiting for her at the security checkpoint, not sitting on his stool. Standing, arms at his sides, feet shoulder-width apart, blocking the path to the metal detector. "Ma'am, I'm going to need to search your bag." "You have an X-ray machine for that." "Manual search, new protocol." She looked at him. "What protocol?" "Courtroom security protocol, effective today." "Is this applied to everyone entering the building?" He didn't answer. A woman behind Nadine, white, mid-60s, carrying a larger purse, walked past both of them, through the metal detector, bag on the belt, and continued to the stairs without being stopped. Scaife didn't look at her. Nadine placed her bag on the counter. Scaife opened it, removed the folder of documents, flipped through them, reading each page, taking his time, removed the notebook, held it up. "What's this?" "A notebook." "What's in it?" "Notes." He opened it, read the first page, or pretended to. His eyes moved across the handwriting without the focus of someone actually reading. Then he set it aside, on his side of the counter, not hers, and continued searching. He removed the water bottle, opened the cap, smelled it, set it down, removed the pens, examined each one, set them aside. Then he reached into the bag's inner zip pocket and pulled out her phone. "I'll need to hold this while you're in the building." That's my personal property. New protocol. Electronic recording devices are prohibited in the courtroom. A personal phone is not a recording device, and courtroom policy allows phones in silent mode. It's posted at the entrance. Scaife held the phone in his palm, looked at it, looked at her. You can have it back when you leave. That is unlawful seizure of personal property without probable cause or a warrant. Something shifted in his face. The casual authority hardened into something more personal. He stepped closer, not threatening exactly, but occupying space, using his height and his width and his uniform to make her smaller by comparison. Ma'am, I'm responsible for security in this building. If I determine that an item poses a security risk, I have the authority to confiscate it during your visit. You're welcome to file a complaint. He placed the phone in a clear plastic bag, wrote her name on it, put it in a drawer behind his station. Then he put her notebook in the same drawer. You can pick up your items when you leave. She stood there. No phone, no notebook. The two tools she'd been using to document everything, gone. Seized by a man who had no legal authority to take them and no policy to cite except one he'd invented that morning. She felt the anger then, not the controlled, clinical anger of a professional doing a job. The raw, personal anger of a human being who'd served her country, who'd bled for it, who'd lost parts of her body defending the principles that were being violated in front of her by a man with a badge and a clipboard and a smirk. She breathed. In through the nose, out through the mouth, the way she'd learned in Kandahar when the IED had detonated and the world had gone white, and the only thing between life and death was the ability to control the next breath. I'd like your name and badge number for the complaint. Scaife, badge 4418. Complaint forms are at the clerk's window. She collected her bag, lighter now, missing its most important contents, and walked to the stairs. Her knee was bad today. The weather had turned cold overnight, and cold made the scar tissue contract, which made the joint stiffen, which made every step a negotiation between will and physics. She climbed. 16 steps, each one a small war. In the hallway outside courtroom B, she sat on the bench and closed her eyes. No notebook to write in, no phone to reference. Just memory. And the device in her jacket pocket, still running, still recording, still capturing every word and every silence and every sound that Rowan Scaife would later wish had never been preserved. The hearing that day was a DUI case. Nothing to do with her. She sat in the gallery and observed the way Briggs handled the defendant, a young man, white, first offense, clearly terrified. His mother sat behind him, clutching a tissue, wearing the kind of desperation that makes strangers look away. Briggs leaned forward. His voice softened, not much, but enough to notice. Enough to create a different atmosphere than the one he'd maintained for every disabled veteran, every person of color, every defendant who dared to ask for something other than punishment. Son, this is your first offense. I'm going to reduce the charge to reckless driving. License suspended 60 days instead of 90. Court costs waived. But I want you to understand, this is your one chance. Don't waste it. The young man nodded, tears running down his face. His mother sobbed audibly, pressing both hands together in a gesture that looked involuntary. Briggs watched them with something that, in a different context, might have passed for compassion. Nadine watched and noted the contrast. The same judge who'd forced a veteran with a shattered knee to stand for 47 minutes. The same judge who'd doubled a fine because a black woman had cited the law posted on his own wall. The same judge who'd threatened contempt for the act of requesting a chair. For this defendant, young, white, represented by a private attorney whose suit cost more than Terrell Boone's monthly disability check, Briggs had found his humanity. It had been there all along. He just didn't extend it to everyone. She committed the details to memory, the exact words, the tone, the contrast between this hearing and every hearing she'd observed for 4 weeks. Not in her notebook. That was in Scaife's drawer, or more likely in a trash can behind Scaife's desk, or in his car, or wherever people put things they've stolen from citizens they consider inconvenient. She would reconstruct every page, every name, every date, every violation. Memory was imperfect, but Nadine's had been trained in environments where forgetting a grid coordinate or a patrol route could get people killed. She wouldn't lose the data. She'd already transmitted copies of the most critical observations to the building with no sign. The notebook was a backup of a backup. Scaife didn't know that. He thought he'd taken her weapon. He'd taken her decoy. At 12:15 p.m., she went downstairs to retrieve her items. Scaife was at his station. He opened the drawer, produced the bag with her phone, and slid it across the counter. Notebook? He looked at her. Blank. What notebook? Her blood went cold, not from fear, from recognition. The leather notebook you confiscated this morning, along with my phone. I confiscated a phone. I don't recall a notebook. She stared at him. He stared back. His face was perfectly composed. The face of a man who'd practiced this particular lie before, who knew the value of simplicity, who understood that denying a thing's existence was more effective than explaining its absence. I'd like to speak with your supervisor. He's not in today. When will he be in? I couldn't say. She took her phone, checked it. The screen showed 12:37 p.m. and no missed calls and no messages, and a battery at 42%. Everything else seemed normal. The notebook was gone. 47 pages of documentation. Names, dates, case numbers, violation counts, witness statements, tray designations, badge numbers. 3 weeks of work. She walked out of the courthouse, down the 7 steps, across the lot to her car. She sat in the driver's seat with the door closed and the engine off, and her hands on the wheel at 10 and 2, and did not move for 4 minutes. Then she reached into her jacket pocket, pressed the device, felt the vibration that confirmed it was still recording, and she almost smiled. Because the notebook was a record. But the notebook wasn't the only record. It was never the only record. The notebook was what they could see. The notebook was what they could take. The device was what they couldn't. November 10th. The third appeal hearing, this time for Terrell Boone, who'd asked Nadine to accompany him as a support person, which Georgia law permitted under certain circumstances for individuals with documented disabilities. They arrived together. Scaife was at his station. He looked at Nadine, then at Terrell, then back at Nadine. His hand moved toward his phone. She's with me, Terrell said. Support person. I've got PTSD documentation from the VA. Scaife made the call, waited. Someone on the other end spoke. He nodded, hung up, and waved them through with a gesture that managed to be both permissive and threatening. No bag search this time. No confiscation. The phone stayed in her pocket. So did the device. They climbed the stairs, entered courtroom B, took seats in the second row. Briggs came out at 9:31, late again. His eyes swept the gallery and landed on Nadine like a searchlight finding its target. He looked at her for 3 full seconds, long enough to communicate recognition, displeasure, and something that might have been calculation. Terrell's case was called at 10:14 a.m. He stood at the podium, hands gripping the rail, right leg trembling. Nadine sat behind him in the first row. Mr. Boone, you failed to appear on October 23rd. A bench warrant was issued. Your Honor, I never received notice of the rescheduled hearing. I have my original notice right here. It says November 14th. He held up the paper. Briggs barely glanced at it. The court's records show notification was sent on October 15th. I never received it, Your Honor. I still have the original. Mr. Boone, the court's records are the court's records. Your failure to appear is not the court's problem. Terrell pressed forward, leaning into the podium, his voice gaining an edge of desperation he couldn't control. Your Honor, I want to submit the original notice as evidence. It proves the court gave me a different date. If the court rescheduled, I should have been notified in writing. Are you telling me how to run my courtroom? No, sir. I'm asking you to look at the document. I've seen the document, Mr. Boone. Briggs hadn't seen it. He'd glanced at it for less than a second, at a distance of 15 feet, while sitting behind a raised bench. But judges don't admit to not looking at things. Judges create realities with their words, and Briggs had just created one in which he'd reviewed and dismissed Terrell's evidence without ever touching it. Mosser stood. The state recommends the fine be increased to $450 with an additional contempt finding for failure to appear. Terrell's voice cracked. Your Honor, I can't. My disability check is $600 a month. I can't pay $450. I was never notified. Then you should have been more careful about checking your mail. A sound from the gallery. Low, involuntary. The collective intake of breath from people who recognized cruelty dressed as procedure. An older woman in the fourth row shook her head slowly, side to side, mouth pressed into a line. The fine is $450. Failure to pay within 60 days will result in arrest. Briggs looked past Terrell, past Nadine, past the gallery full of people who were watching a man with a Purple Heart and a tremoring hand be ground down by a system designed to produce fines rather than justice. Next case. Terrell stood at the podium for a moment, not moving, not speaking. His right hand shook against the rail. His left hand, the steady one, slowly curled into a fist at his side. A vein in his temple pulsed, visible even from where Nadine sat. Then he turned and walked back to Nadine, sat down hard. The bench creaked. He put his face in his hands and kept them there, fingers laced behind his skull, the posture of a man holding his own head together. She put her hand on his shoulder, didn't speak, just held it there, a point of contact, a reminder that he wasn't alone, even though every institution in this building had made it clear that he was. They sat through 3 more cases. Then Nadine saw something that changed the timeline. A woman in a motorized wheelchair approached the courtroom entrance. She was older, 70s maybe, with a U.S. Marines veteran cap and an oxygen tube running to a portable concentrator mounted on the wheelchair's frame. She rolled up to the 4 steps leading down into the courtroom and stopped. No ramp, no lift, no way down. Nolan Gist was at the door. He looked at the woman, looked at the stairs, looked at his watch. Ma'am, you'll need to leave the wheelchair up here. Someone can help you walk down. I can't walk. That's why I have the wheelchair. We don't have wheelchair access to this courtroom. Then how am I supposed to attend my hearing? Gist shrugged. Physically shrugged. Shoulders up, palms out. The universal gesture of not my problem. You can request a continuance through the clerk's office. I've already been continued twice. The judge said if I don't appear today, he'll issue a warrant. Gist looked at her the way a man looks at a traffic cone. An obstacle in his path, not a person with rights. Then he reached for the wheelchair's handles. I'll carry you down. Don't touch my chair. The woman's voice was sharp, military grade, the voice of someone who'd given orders and expected them followed. Gist stepped back, hands up. Nadine stood. She walked to the entrance. She addressed Gist, her voice low enough that only he and the woman could hear. Under 28 CFR, Section 35.15. Public entities must ensure that programs and activities are accessible to individuals with disabilities. If the courtroom is physically inaccessible, the court is required to relocate the proceeding to an accessible location. That's not optional. Gist stared at her. Who asked you? Nobody. She turned to the woman. Ma'am, would you like me to help you request a relocation of your hearing to an accessible courtroom? The woman looked at Nadine, then at Gist, then at the stairs that separated her from her legal proceeding and her constitutional right to appear before a judge who would issue a warrant if she didn't. Yes, she said. Please. Nadine walked, limping, cane clicking, back to the clerk's window. Meredith Lyle was there. Of course she was. I need to request an emergency relocation of a hearing to an accessible courtroom. There's a wheelchair user who can't access courtroom B. Meredith didn't look up from her computer. We don't have accessible courtrooms. then the hearing needs to be held in a location that is accessible. A conference room, a first-floor office, anywhere with wheelchair access. That's not how we do things here. It's how the law requires you to do things. Everywhere. Meredith looked up. The smile was gone. What replaced it was the naked face of institutional power, the expression of a person who knows the system will protect them and is counting on it. Ms. Okafor, I'm going to have to ask you to step away from the window. You're not a party to that woman's case, and you don't have standing to make requests on her behalf. She asked me to help her. She can come to the window herself. She can't. That's the entire point. It was the first time Nadine had raised her voice in 3 weeks. The words echoed off the marble walls. Heads turned. Conversations stopped. Meredith reached for the phone on her desk. I'm calling security. Scaife arrived in 45 seconds. Fast. Too fast. He'd been nearby, waiting, maybe stationed there specifically for this possibility. Ma'am, you need to step away from the window. I'm requesting an accommodation on behalf of another citizen. You need to step away now. He grabbed her arm. Left arm, just above the elbow. Not gently. Not the careful restraint of a trained officer. The grip of a man asserting control through contact. His fingers dug into the muscle, compressing the nerve underneath. Pain shot from her elbow to her shoulder. She did not pull away, did not struggle, did not raise her voice again. She looked at his hand on her arm, then at his face, and said, very quietly, You are committing battery on a disabled person in a public building. There are 11 people watching you do it. Scaife's grip loosened, not from conscience, from the awareness that she was right about the 11 people. He let go, stepped back. Leave the building, ma'am. I have a right to be here. Not anymore you don't. You're trespassing. A public courthouse is not private property. I can't trespass in a building I have a legal right to enter. He took a step toward her. Close. Too close. His chest almost touching her shoulder. His voice dropped to a register that the 11 watching people couldn't hear. You've been coming in here every week, writing things down, asking questions, making people nervous. I don't know what your game is, lady, but I promise you, you do not want to play it in Carver County. She looked up at him. 6'2" to her 5'6". 220 pounds to her 140. A man with a badge and a building and the full weight of a county government behind him, and a woman with a cane and a jacket and a button-sized device, recording every syllable he'd just whispered. I'd like to leave now, she said. He stepped aside. She walked past him, past the clerk's window, past Meredith's carefully reconstructed smile, past the metal detector and the stool and the drawer where her notebook had disappeared 9 days ago and was never coming back. At the door, she turned. The woman in the wheelchair was still at the top of the courtroom steps, still unable to enter, still waiting for a system designed to serve her, to acknowledge that she existed. The woman's name was Claudette Marsh. Nadine would learn this later. 73 years old. Staff sergeant retired. 2 tours in Vietnam as a field nurse. One of the first black women to serve in a combat medical unit. She'd spent her career saving lives and her retirement fighting the county for a wheelchair ramp at the post office, at the library, at the DMV, and now at the courthouse. She'd been fighting for 6 years. She was tired, but she was still fighting. Claudette looked at Nadine from across the lobby. 40 feet of marble between them, and between them, everything Carver County had built to keep people like them on the outside of the systems designed to serve them. Claudette raised one hand. Not a wave. A salute. Slow, deliberate, the muscle memory of a woman who'd rendered honors to flag and country for 3 decades. Her fingers trembled. Age, not fear. But the gesture was precise. Nadine returned it. Just once. Then she pushed through the glass door and walked into the November sun, down the 7 steps, each one sending a jolt through her knee that she absorbed the way she absorbed everything in Carver County, with discipline and without complaint. Across the lot to her gray Nissan. She sat in the driver's seat. left arm throbbing where Scaife had grabbed her. She could see the marks forming, 4 red ovals pressed into the skin above her elbow, the middle 2 deeper than the others where his fingertips had dug into the muscle. She rolled up her sleeve. The bruises were already darkening, not yet purple, but heading there, the subcutaneous bleeding visible beneath her skin like a map of someone else's rage. She photographed them with her phone. 4 shots, close-up, medium, with the car's clock visible for timestamp, with the courthouse entrance visible through the windshield for location. Saved each one. Then she pulled down her sleeve, started the engine, and sat for another moment. Her hands were shaking. Not from the pain, not from the confrontation, from the effort of not reacting, of standing in a public building and being grabbed by a man twice her size, and choosing, deliberately, strategically, at enormous personal cost, to let him do it, to let the device record it, to let the bruises form, to let the evidence accumulate on her body the way it accumulated on the recorder, silently, completely, without the catharsis of resistance. She had been trained to fight. She had fought, in places and circumstances that made Rowan Scaife look like what he was, a small man with a small job in a small county courthouse. But fighting him would have ended the investigation. One defensive move, one raised arm, one moment of the instinct that had kept her alive in Kandahar, and they'd have arrested her for assaulting a court officer. Case closed, evidence inadmissible. Carver County wins. So she'd stood there, and she'd let him, and the device had recorded it, and the bruises were the proof. She exhaled, started the car, then she drove. Not to the motel, past it, left on Route 9, to the building with no sign. The door opened before she knocked. This is just the beginning of what Carver County tried to bury. If you want to know what they did to the evidence, and what Nadine found when she pulled the server logs, stay right here. Part 2 is coming, and the reveal will leave you speechless. The meeting lasted 2 hours. When it ended, Nadine walked to her car in the dark. The Bradford pear trees along the building's perimeter had dropped most of their leaves, and the branches clicked against each other in the wind like the bones of something skeletal and patient. She checked her phone. 2 missed calls. The first was from Terrell Boone. She'd call him tomorrow. The second was from a number she didn't recognize. No voicemail. No text. Just a missed call at 6:14 p.m. from an 843 area code, South Carolina, that lasted 1 ring and left no trace except the timestamp. She stared at it. Then she opened her contacts, scrolled to a name, and typed a message she didn't send. The cursor blinked in the text field for 30 seconds before she deleted the draft, pocketed the phone, and started the engine. On the drive back, she passed the courthouse. It was dark. Closed hours, lot empty, except for one window on the 2nd floor. Judge Briggs's chambers. The light was on. And in the parking lot, next to the building's side entrance, a white Ford F-150 with plate number GCH4419 sat idling. The same truck that had been illegally parked in the disability space on her first day. Engine running. Headlights off. Someone sitting in the driver's seat, face lit by the blue glow of a phone screen. Nadine slowed, noted the time, 7:48 p.m., noted the plate, noted the light in Briggs's window. Then she drove past. The motel was 3 miles ahead. The letter from the VA Medical Center was still on the nightstand, unopened. The ice machine in the parking lot hummed its broken song. She would open the letter tomorrow, or the day after. Some things you could control the timing of, and some things controlled you. But the one thing she knew, the one thing 3 weeks in Carver County had confirmed with the certainty of artillery coordinates locked on target, was that this courthouse was not an isolated incident. It was a system designed to discourage, to deny, to erase. A system that treated disabled veterans like clerical errors to be resolved, not citizens to be served. A system that a single judge had built, and a single administrator had maintained, and a single security officer had enforced, and an entire county had permitted through the simple, devastating act of looking the other way. And systems, she knew, don't fall from one person pushing. They fall when the documentation is so complete, so meticulously assembled, so impossible to dismiss that even the people who built the system can't pretend it doesn't exist. She had the documentation, she had the recordings, she had the names and the dates and the violations and the pattern. What she didn't have, not yet, was the server logs that would show who'd deleted the complaints, the email chain that would reveal who'd ordered the elevator left broken and the ramp left unbuilt, the internal communication that connected Briggs to Lyle to Gist to Scaife in a chain of deliberate, coordinated obstruction that turned a county courthouse into a machine for grinding down the people it was supposed to protect. But she would. Because tomorrow morning, at a federal building with no sign on the door, a forensic analyst named Diana Chow would begin downloading the data from Nadine's recording device. 3 weeks of audio, captured in hallways and courtrooms and security checkpoints and clerks' windows and whispered threats too quiet for 11 witnesses to hear, but loud enough for 64 gigabytes of storage to preserve forever. And once that data was authenticated, time-stamped, and entered into evidence, once the chain of custody was established and the transcripts were prepared and the pattern was laid out in the cold, clinical language of federal compliance review, Nadine Okafor would go back to Carver County Courthouse one more time, but she wouldn't go alone. And she wouldn't go as a woman with a limp and a parking ticket. She'd go as exactly who she was, and the lock on Judge Briggs's career would click twice, once for the investigation, once for the finding, and then there would be silence. The kind of silence that fills a courtroom when everyone in it realizes, at the same moment, that the person they'd dismissed, denied, confiscated, grabbed, threatened, and erased was the one person in the building with the authority to hold them all accountable. That silence was coming. It was 3 weeks away, and it would be deafening. But tonight, the motel, the thin walls, the rattling window unit, the letter she wouldn't open, the phone call she wouldn't return, the bruises forming on her left arm where a man had grabbed her for the crime of asking that a wheelchair user be allowed to attend her own hearing. Nadine Okafor turned off the car, picked up her cane, and walked to room 14. The door closed behind her. The lock clicked once, and in her jacket pocket, the device kept recording, capturing nothing now but the sound of a woman breathing in a quiet room, alone, doing the hardest thing a person can do when they know what's coming. Waiting. End of Part 1. Part 2 continues with the federal investigation, the server logs that expose the deletion of 3 veterans' complaints, and the moment Nadine Okafor walks into courtroom B for the last time, not as a defendant, but as something Judge Caldwell Briggs never imagined she could be. Judge pushes a disabled veteran too far. Seconds later, the court falls silent. Part 2. The building with no sign sat 40 minutes east of Carver County on a road that didn't appear on most GPS systems. Single-story, brick, federal-issue blinds in the windows, a parking lot designed for 12 vehicles but rarely holding more than 4. The kind of place that existed to be overlooked. Nadine pulled in at 8:17 p.m. The lot held 2 cars, a black Chevrolet Impala with government plates and a silver Honda that belonged to Diana Chow, the forensic analyst who'd been assigned to the case 6 months before Nadine ever set foot in Carver County. Inside, the building was exactly what it appeared to be, a satellite field office, temporarily leased, barely furnished. 2 desks, 4 chairs, a server rack in a back closet, and a conference table covered in file boxes, printed emails, and a large format timeline pinned to the wall that stretched from January 2023 to the present day. Raymond Jessup stood at the timeline. 51 years old, gray at the temples, reading glasses pushed onto his forehead, suit jacket hung over a chairback. Senior Counsel, Civil Rights Division, United States Department of Justice. 23 years with the department. 7 pattern or practice investigations. 4 consent decrees. He'd seen systems break before, and he knew that breaking them required patience and proof in equal measure. He turned when Nadine entered, saw the way she was walking, slower than usual, favoring the left leg more heavily, left arm held close to her body. "What happened to your arm?" She set her bag on the desk, removed her jacket, rolled up her sleeve. Jessup looked at the bruises. 4 ovals, now purple-black against her brown skin, the finger marks distinct and unmistakable. He didn't speak for a moment. Then he pulled out his phone and photographed them. 3 angles, close up, with a ruler from his desk drawer placed beside the marks for scale. Court Security Officer, Rowan Scaife, badge 4418. She sat down carefully. I was requesting an accommodation for a wheelchair user who couldn't access the courtroom. Meredith Lyle called security. Scaife grabbed my arm and told me to leave. Witnesses? 11 at least. Open lobby. But I wouldn't count on any of them coming forward voluntarily. Carver County has a way of making witnesses forget what they saw. Jessup set down his phone, looked at the timeline on the wall. 34 months of complaints, denials, erasures, and institutional resistance, all leading to this moment, this room, this woman with bruises on her arm from a building that posted federal disability law on its walls and violated it in every interaction. Diana recovered the server data, he said. You should see what she found. Diana Chow emerged from the back room. Mid-30s, slight build, wire-rimmed glasses, the expression of someone who spent most of her waking hours staring at metadata and finding patterns in things other people deleted. She carried a laptop, which she set on the conference table and opened. I ran the extraction on the Carver County Court Records server backup last night. The county uses a standard case management system, Tyler Technologies Odyssey, version 9.2. They have a backup that mirrors to an off-site disaster recovery facility in Macon every 72 hours. They probably don't know about the Macon backup, because the contract was set up by a previous IT director who left in 2021 and nobody reviewed the service agreement. She turned the laptop toward Nadine. On the screen, a log file, time-stamped entries, each line a record of a digital action taken on the county's server. This is the access log for October 18th, 2025. Watch the timestamps. Nadine read. The entries were technical, but the story they told was simple. 1:42 a.m. user n.gist logged in. Admin access. 1:44 a.m. File ADA-504-2025-031 accessed. Status changed from active to archived. 1:44 a.m. File AD-504-2025-032 accessed. Status changed from active to archived. 1:45 a.m. File ADA-504-2025-033 accessed. Status changed from active to archived. 1:47 a.m. Files ADA-504-2025-031, 032, 033 deleted from archived folder. 1:47 a.m. Recycle bin emptied. 1:48 a.m. User n.gist logged out. 6 minutes. 3 complaints. Nadine's, Terrell Boone's, and Deshaun Niles's. Accessed, archived, deleted, and scrubbed from the system in 6 minutes at 1:42 in the morning. He used admin credentials, Diana continued. Bailiff Gist doesn't have admin access in the normal course of his duties. Someone gave him the login, or he obtained it without authorization. Either way, this is destruction of federal records. 18 U.S.C. Section 1519. Nadine stared at the screen. She'd suspected it. She'd known, in the way you know things when patterns become too consistent to be coincidence, that the missing complaints hadn't been lost. They'd been erased. But seeing it, reading the timestamps, watching the digital trail of a man who'd sat at a computer at 1:42 in the morning and systematically removed evidence of disability discrimination from a federal database, that was different. That was proof. There's more, Diana said. She pulled up an email chain recovered from the server backup. From m.lyle@carvercounty.gov to n.gist@carvercounty.gov. Date, October 14th, 2025, 4:47 p.m. Subject, READA complaints. Nolan, Judge B wants all 504 forms filed under general correspondence, not a DA tracking, same as last quarter. Don't log them in this federal system. M. Reply. From n.gist@carvercounty.gov to m.lyle@carvercounty.gov. Date, October 14th, 2025, 5:02 p.m. Got it. What about the 3 from the veterans? They have tracking numbers. Reply, from m.lyle@carvercounty.gov. Date, October 14th, 2025, 5:11 p.m. Handle it after hours. Use the admin login I sent last month. Remove them from the active queue and clean the archive. The fewer records, the fewer questions. Nadine read the chain twice. Then she sat back in her chair and closed her eyes. Judge B, she said. Judge Briggs, Jessup confirmed. Lyle references him by initial, but the context is unambiguous. He's directing the suppression of ADA complaints through his court administrator, who's directing the bailiff to delete them using admin credentials he shouldn't have. That's conspiracy. That's a pattern. And it's exactly what we needed. Jessup laid out the case on the conference table. Printed emails, server logs, Nadine's audio transcripts, 3 weeks of recordings, now professionally transcribed by a DOJ contractor with timestamps and speaker identifications, photographs of the bruises on Nadine's arm, photographs of the missing wheelchair ramp, the broken elevator, the illegally occupied disability parking spaces, signed declarations from Terrell Boone, Deshaun Niles, and Arturo Reyes, a declaration from Curtis Vega, the partially blind veteran whose service dog had been grabbed by Nolan Gist, a declaration from Claudette Marsh, the wheelchair-bound Marine veteran who'd been denied access to her own hearing. 6 veterans, 6 violations, 1 courthouse, 1 judge, 1 system. Here's where we are. Jessup stood at the whiteboard, marker in hand. We have enough for a compliance review letter under Title 242 U.S.C. Section 12133. That's the standard entry point. We notify the county that we've identified a pattern of ADA violations and request voluntary compliance. They won't comply voluntarily. No, they won't. Which is why we're going to do something else first. He uncapped the marker. We're going to walk into courtroom B and announce the review in open session. On the record, in front of the gallery, the court reporter, and every person in that building. Nadine looked at him. Including Briggs. Especially Briggs. I want him to hear it from us in his courtroom with his people watching. Because if we do this by letter, it goes into the same tray Meredith Lyle uses for everything else. General correspondence. And in 6 months they'll tell DOJ they never received it. He wrote on the whiteboard, Compliance Review, Open Court Announcement. Then, below it, Reveal, Okafor. Your cover, he said. It ends that day. They'll know who you are. They'll know what you've been doing. And they'll know that everything they said and did for the past 5 weeks has been recorded, documented, and submitted to the Department of Justice. Nadine was quiet for a long moment. The humming of the server rack in the back room filled the silence. Diana's keyboard clicked softly as she continued extracting data. When? Nadine asked. November 24th, Monday, the heavy docket day, maximum gallery, maximum witnesses. 13 days away. If you've made it this far, you already know this isn't a normal story. Subscribe and turn on notifications, because what happens in that courtroom on November 24th is going to leave you speechless. The 13 days passed in preparation. Jessup filed the internal paperwork, request for compliance review authorization, evidence summary, jurisdiction memo citing 42 U.S.C. Section 12133 and 28 CFR Part 35. The authorization came back from the Assistant Attorney General for Civil Rights in 8 days, which was fast by federal standards and glacially slow by the standards of the veterans who'd been waiting years. Federal Monitor Helen Dow arrived from Washington on November 20th. 58 years old, former judge on the D.C. Superior Court, now serving as a court-appointed monitor in 3 separate ADA compliance cases across the Southeast. She was small, precise, and carried herself with the quiet authority of someone who'd spent 30 years in courtrooms and understood that power didn't require volume. She met Nadine at the building with no sign on the evening of November 22nd, 2 days before the hearing. "Ms. Okafor?" Dow shook her hand with both of hers, a gesture that was warm but also deliberate, the kind of greeting that acknowledged what Nadine had endured without turning it into a spectacle. "Raymond showed me the transcripts and the photographs of your arm. It's healing. That's not the point, and you know it." Dow sat down at the conference table. "Walk me through the courtroom. Layout, entrances, sight lines. I want to know exactly what we're walking into." Nadine described Courtroom B in detail. The 4 steps down from the hallway, the narrow center aisle, the raised bench, the ADA plaque on the wall, the placement of Gist near the door, Scaife at the security checkpoint, Meredith at the clerk's window, the absence of accessible seating, assistive listening devices, wheelchair spaces. Dow listened, took notes, asked precise questions. When Nadine finished, Dow set down her pen and looked at her. "The last compliance review I monitored, Jefferson County, Alabama, 2022, the county fought the consent decree for 18 months. They hired outside counsel, challenged jurisdiction, argued that every violation was isolated and unrelated. They lost eventually, but the 18 months cost the plaintiffs, disabled residents who couldn't access their own courthouse, another 1.5 years of denied accommodations while lawyers argued about whether the law applied. You think Carver County will fight it? I think Caldwell-Briggs will fight it. Personally. Because this isn't about the ramp or the elevator or the parking spaces. This is about a man who's built a fiefdom in a small county courtroom and doesn't intend to let the federal government dismantle it. Then we need to make it impossible for him to fight." Dow looked at her. A long look, appraising, the look of a former judge assessing a lawyer's readiness for the most important hearing of her career. "You've been living in a motel for 5 weeks, documenting violations in a courthouse where a man twice your size grabbed you hard enough to leave marks. You've climbed stairs you shouldn't have to climb, stood when you shouldn't have had to stand, and let them take your notebook without flinching. Raymond tells me you haven't taken a day off." "I'll take a day off when Carver County has a wheelchair ramp." Dow almost smiled. "Almost. Your mother called Raymond's office yesterday, Dorothy Okafor. She wanted to know if you were eating." Something shifted in Nadine's expression. Not much, just the faintest softening at the edges, the involuntary response of a woman who'd been alone for 5 weeks and hadn't let herself think about the people who worried about her. "I'm eating." She also asked when you were coming home. Nadine didn't answer that one. Instead, she opened her bag and pulled out a folder, the one she'd carried into the courthouse every morning, the one Scaife had flipped through and dismissed, the one that contained nothing sensitive because the sensitive materials were here, in this building, behind a lock that required 2 keys and a 6-digit code. "November 24th, she said. "We go in at 9. Shepherd." The morning of November 24th was cold. 38 degrees, overcast, the kind of Georgia morning where breath made ghosts in the air and the courthouse steps were slick with condensation. Nadine dressed differently. Not the casual blazer and slacks of her previous visits, but a charcoal suit, tailored, pressed, professional. The suit she'd worn in federal court in Atlanta 11 months ago when she'd argued a Title II case against a county jail that had refused wheelchair access to its visitation room. She'd won that case. The suit felt like armor. She checked her bag. Not the old routine, the new one. Federal credentials in the inside pocket. DOJ identification card in its leather case. A printed copy of the compliance review authorization, signed by the Assistant Attorney General. 3 copies of the evidence summary, bound and tabbed. No recording device. She didn't need it anymore. She drove to the courthouse with Jessup in the Impala. Dow followed in a separate vehicle. They parked in the lot at 8:43 a.m. The disability parking spaces were occupied again. Same white F-15, plate GCH 4419. No placard, Nadine noted it. Jessup photographed it, force of habit. They climbed the 7 steps to the entrance. Nadine took them one at a time, cane in her right hand, Jessup beside her, not helping, not hovering, just present. Dow followed, inside, the metal detector, the conveyor belt, and Rowan Scaife on his stool, scrolling his phone. He looked up, saw Nadine. His expression shifted. The usual assessment, the territorial awareness. Then he saw Jessup. Then Dow. 2 people in federal-grade suits walking with a woman he'd grabbed and threatened, and whose notebook he'd stolen. Something changed in his posture. Not fear, not yet, but the beginning of uncertainty. The first fissure in the confidence of a man who'd never had to answer for anything he'd done inside this building. Bag on the belt. All 3 placed their bags on the conveyor, stepped through the detector. Clean. On the other side, Scaife stood, his full height, blocking, the same positioning he'd used the last time Nadine was here, feet planted, arms wide, the physical vocabulary of a man who controlled access and knew it. He reached for Nadine's bag. Habit, muscle memory, the reflexive assertion of dominance over a woman he'd learned to treat as something less than a citizen. Jessup's hand landed on the bag first, not grabbing, just resting there, fingers flat, palm down. A barrier that was also a statement. Federal property. 2 words. Quiet. The kind of quiet that carries more weight than volume. Scaife's hand stopped, hovered, then withdrew, slowly, curling into a fist at his side. He looked at Nadine. She looked back. Same height difference, same power imbalance of size. But something had shifted. The last time they'd stood this close, he'd grabbed her arm, and she'd let him because the mission required it. This time, she was wearing credentials, and he was wearing the beginning of the end of his career, and they both knew it. "Morning, Mr. Scaife," she said. Neutral, professional, the voice of a woman who'd spent 5 weeks absorbing his contempt and was now returning it as courtesy, which was worse. He didn't respond. His jaw worked. His eyes moved from her face to the credentials visible in Jessup's breast pocket and back. She collected her bag, walked past him. Jessup and Dow followed. Behind them, Scaife picked up his phone. His thumb moved across the screen. Fast, urgent, the panicked texting of a man who needed to warn someone and wasn't sure who to warn first. Meredith. Gist. Briggs's clerk. The chain of communication that had kept Carver County insulated for years, now firing in reverse. Not to suppress information, but to broadcast a warning that the information was no longer theirs to suppress. The hallway outside Courtroom B was crowded. Monday docket, 30 cases. The benches were full. Defendants, families, lawyers, the same cross-section of Carver County that filled this hallway every week, waiting for their names to be called and their fates to be decided by a man in a black robe who didn't believe in accommodations. Nadine saw familiar faces. The woman with the hearing aid from 3 weeks ago. The father with the infant. 2 men she recognized from the gallery. Regulars. People who came to court the way some people come to a hospital, repeatedly, because the system kept generating reasons for them to return. And in the corner, standing apart from the crowd, a man she hadn't expected. Pastor Vaughn Ridley, 62 years old, tall, wearing a dark overcoat over a pressed shirt, no tie. He ran the community outreach center on the east side of town, the one that provided legal aid referrals and VA benefits counseling and hot meals on Thursdays. He'd been helping disabled veterans navigate Carver County's bureaucracy for 8 years. He saw Nadine, crossed the hallway. When he reached her, he did something she'd noticed he always did. He straightened slightly, the way a person straightens when addressing someone they consider an equal or a superior. Not deference, respect. The kind that comes from recognizing something in another person that transcends the surface. "Ms. Okafor." He extended his hand. "I wasn't sure you'd come back." She shook it. "I wasn't sure either, but here I am." He looked at Jessup, at Dow, at their suits, their bags, the way they carried themselves. He didn't ask who they were. He didn't need to. Vaughn Ridley was a man who understood that some mornings arrive differently than others, and this morning had arrived with federal credentials and the weight of something about to change. "Whatever happens in there," he said quietly, "it's been a long time coming." She nodded. "Once." The courtroom doors opened. Meredith Lyle stood in the doorway. Clipboard, glasses, the smile. All parties for the 9 a.m. docket. She stopped. She'd seen Jessup. She'd seen Dow. She'd seen Nadine standing with them, dressed differently, carrying herself differently, the cane the same, but everything else changed. Meredith's smile vanished. She looked down at her clipboard, then back up, the calculation visible on her face, the rapid assessment of a woman who'd spent years controlling access to this courtroom and was now confronting the possibility that access was no longer hers to control. She stepped aside. They entered. The 4 steps. Nadine descended them the same way she always had, sideways, 1 step at a time, cane and rail, slow and deliberate. Jessup and Dow followed. The gallery was nearly full, 30, maybe 35 people. Nadine took a seat in the first row. Jessup and Dow sat beside her. Briggs entered at 9:18 a.m. Late, as always. He settled into his chair, adjusted his microphone, opened his file. Then he looked up. His gaze swept the gallery the way it always did, quickly, without interest. The scan of a man who viewed the people in his courtroom as items on a list rather than citizens in his care. His eyes reached the first row, stopped. He recognized Nadine. That was instant. The slight narrowing of his eyes, the tightening of his jaw, the body language of a man confronting someone he'd hoped wouldn't return. Then he saw Jessup, then Dow. 2 people he'd never seen before sitting in his courtroom, wearing suits that cost more than his monthly salary, looking at him with the composed, patient expressions of people who had time and authority and weren't in a hurry to use either. Something crossed his face. Not fear. Not yet. But the beginning of it. The hairline fracture in the foundation of a man who'd operated unchallenged for 11 years and was now confronting the fact that he'd miscounted. He cleared his throat. "First case on the docket. Your Honor." Jessup stood, not quickly, not dramatically. The measured rise of a federal attorney who'd done this before and knew that the first words mattered more than any that followed. "Before the court proceeds with its docket, I have a matter that requires the court's immediate attention." Briggs stared at him. "Who are you?" "Raymond Jessup, Senior Counsel, Civil Rights Division, United States Department of Justice." He held up his credentials. Leather case, gold seal, the full weight of the federal government distilled into a laminated card. Pursuant to 42 U.S.C. Section 12, 133 and 28 CFR Part 35, the Department has opened a compliance review of Carver County's court facilities and judicial proceedings for systemic violations of Title II of the Americans with Disabilities Act. Silence. Not the ordinary silence of a courtroom between sentences. Something deeper. Something that started in the front row and spread backward through the gallery like a wave moving through still water. The collective realization that what was happening in this room was not on anyone's docket, not in anyone's file, not something the court administrator had anticipated, or the bailiff had been warned about, or the judge had prepared for. Jessup continued. His voice was level, unhurried, carrying the authority of a department that had dismantled police departments and restructured school districts and forced entire state governments to comply with federal law. "I'd also like to introduce the members of the review team. Federal Monitor Helen Dow, appointed by the department to oversee compliance proceedings." Dow stood. Brief nod, sat down. "And Senior Trial Attorney Nadine Okafor, Special Litigation Section, Civil Rights Division." Nadine stood, slowly, the cane, the knee, the familiar mechanics of a body that worked against itself every time it moved. But she stood. She looked at Briggs. He looked at her. And the courtroom fell silent. The silence lasted 7 seconds. Nadine counted. 7 seconds in which Caldwell Briggs processed the fact that the woman he'd denied a chair The woman he'd threatened with contempt for asking to sit down, the woman whose fine he'd doubled, whose appeal he'd denied, whose cane had been confiscated by his security officer, whose notebook had been stolen by his bailiff, whose arm had been bruised by his staff, was a federal attorney who'd been recording every word, a federal attorney with the power to dismantle his courtroom. Briggs's hands moved to the bench surface, flat, fingers spread, the gesture of a man steadying himself against something he couldn't see but could feel, the ground shifting beneath 11 years of unchecked authority. Mosser stood halfway up from his chair, then sat back down. His mouth opened, closed, opened again. He looked at Briggs for direction. Briggs couldn't give any. In the gallery, Nolan Gist was standing at the rear door. His face had gone pale, not ashen, not dramatic, just the steady draining of color that accompanies the realization that the things you did at 1:42 in the morning are no longer invisible. Meredith Lyle sat in her usual spot by the clerk's station. Her hands were under the desk. Her phone screen glowed faintly against her lap. She was typing, texting someone, alerting someone, activating whatever emergency protocol existed for moments when the system's walls began to crack. Briggs found his voice. It came out smaller than usual, not weak but reduced, the volume dial turned down by the presence of 3 people in his courtroom who didn't answer to him. "Mr. Jessup, this is highly irregular. If the Department of Justice has a matter to bring before this court, the appropriate procedure is to file—" "Your Honor, this is not a judicial proceeding." Jessup's tone was respectful, also final. "This is a federal compliance notification. Under the Supremacy Clause, Article 6, Clause 2, we're required to inform you that a review is underway and to request your cooperation. We're not requesting permission." Briggs's jaw moved, the grinding motion. Nadine recognized it. She'd seen it every time he was about to deny something. "I'd like to consult with the county attorney before this proceeds." "That's your right, Your Honor. But the review has already begun. It began 5 weeks ago." 5 weeks. The number landed in the courtroom like a stone dropped in a well. 5 weeks. The exact duration of Nadine's presence in Carver County. Every visit, every observation, every denied accommodation, every confiscated cane, every deleted file. Briggs looked at Nadine, and for the first time she saw it. Not the irritation of a judge dealing with a difficult defendant, but genuine fear. The fear of a man who'd built his authority on the assumption that nobody was watching and had just learned that someone had been watching the entire time. "Ms. Okafor has been—" Senior Trial Attorney Okafor has been conducting an on-site assessment of Carver County's ADA compliance as part of the department's preliminary investigation, Jessup said. Her observations, recordings, and documentation form a significant portion of the evidentiary basis for this review. "Recordings?" Mosser was on his feet now. "Your Honor, if federal agents have been conducting covert recordings in this courthouse without— Georgia Code Section 16-11-62 is a one-party consent state." Nadine's voice, the first time she'd spoken since the hearing began. Steady, clear. No tremor, no anger, no triumph. Just the precise, clinical delivery of a legal fact by a woman who'd spent 5 weeks earning the right to say it. "I was a party to every recorded conversation. The recordings are lawful." Mosser sat down, slowly, like a man lowering himself into water he suspects is deeper than it looks. This is the moment everything changes. If this story has moved you, share it with someone who needs to hear it, because what comes next proves that fighting back isn't just possible, it's necessary. Jessup presented the evidence. Not all of it. The full evidentiary file was 412 pages, plus 17 hours of audio, plus the server data. That would come later, in formal proceedings. What he presented now was the summary, the highlights, the pattern, the undeniable. He read from the DOJ evidence summary. His voice carried through the courtroom speakers with the dispassionate clarity of a man who'd learned long ago that facts don't need drama to be devastating. Exhibit A, audio recording, DOJ, issued covert device, serial number FR-20225-0847, authenticated by DOJ Digital Forensics Unit, November 15, 2025. Chain of custody established by forensic analyst Diana Chow. Transcript excerpt, October 17, 2025, timestamp 14/23/41. Voice identified as Rowan Scaife, badge number 4418. Quote, another one with the Kane Act. Voice identified as Nolan Gist. Quote, make sure the intake form says she was offered a seat and declined. End quote. The gallery murmured. Scaife, who'd been standing near the rear door, took a half-step backward. The involuntary retreat of a man hearing his own words, played back in a room full of people who now knew exactly what he'd said when he thought nobody important was listening. Exhibit B, internal email chain, recovered from Carver County Court Record Server Backup, Macon Disaster Recovery Facility. Email dated October 14, 2025, 4:47 p.m. from user m-lyle at carvercounty-gov to user n-gist. Subject, ADA complaints. Text, Nolan, Judge B wants all 504 forms filed under general correspondence, not ADA tracking. Same as last quarter. Don't log them in the federal system. Meredith's phone slipped from her fingers. It clattered against the desk. She didn't pick it up. Exhibit C. Server access log, Carver County Court Records Server. October 18, 2025, 1:42 a.m. User n-gist, admin access. 3 ADA complaint files. Numbers 031, 032, 033. Accessed, archived, and deleted within 6 minutes. FBI Cyber Division Forensic Analysis. Case number GA-CRD-2025-1104. Confirmed file recovery from off-site backup. The deleted files correspond to complaints filed by disabled veterans, Nadine Okafor, Terrell Boone, and Deshaun Niles. Gist was no longer standing at the rear door. Nadine turned her head. He was gone. His spot empty, the door to the hallway swinging slowly on its hinges. She could hear footsteps in the corridor, fast, receding. The sound of a man running from a room where his name had just been attached to 18 U.S.C. Section 1519, Destruction of Records in a Federal Investigation. Briggs gripped the edge of his bench. His knuckles were white. His face had settled into something rigid, not rage exactly, not panic, but the frozen mask of a man who was processing the collapse of everything he'd assumed about his own invulnerability and hadn't yet decided how to react. Exhibit D. Photographic evidence of battery committed against senior trial attorney Okafor by Rowan Scaife on November 3, 2025. Bruising documented on left arm above the elbow, consistent with forceful grip. Photographs taken with timestamp and location data within 15 minutes of the incident. Jessup set down the summary, looked at Briggs. Your Honor, the Department of Justice is prepared to file a formal compliance action against Carver County under 42 U.S.C. Section 12133. If the county does not enter into voluntary compliance negotiations within 30 days. The action will seek injunctive relief, including but not limited to installation of wheelchair-accessible facilities at all county court buildings, appointment of an ADA coordinator, comprehensive training for all court personnel, and a federal monitor to oversee compliance for a period of no less than 24 months. He paused. Let it settle. We are also referring the evidence of records destruction and obstruction to the United States Attorney for the Middle District of Georgia for potential criminal prosecution under 18 U.S.C. Section 1519. And we are referring the evidence of battery against a federal officer to the same office under 18 U.S.C. Section 111. Briggs' voice came out as a rasp. I had nothing to do with the deletion of any records. The email evidence suggests otherwise, Your Honor, but that determination will be made by the U.S. Attorney, not by this review. Briggs looked at the gallery. 35 faces looking back at him. Some shocked, some confused. Some, the ones who'd been fined, denied, threatened, and ground down by this courtroom for years, wearing expressions that were harder to name. Not joy, not vindication. Something quieter. The look of people watching a locked door open for the first time and not yet trusting that it would stay open. Terrell Boone was in the fifth row. He'd come on his own, without being told about the hearing, without knowing what was about to happen. He'd come because it was Monday, and because he still had an outstanding fine, and because he was the kind of man who showed up even when showing up meant pain. He was crying, silently, tears running down his face and into the collar of his flannel shirt, his VFW cap straight on his head, his right hand trembling on his knee. Beside him, Pastor Vaughn Ridley sat with his hands folded, not crying, not smiling, watching with the patient, exhausted expression of a man who'd been waiting 8 years for this moment and knew that moments like this were only beginnings, never endings. Briggs stood. The motion was abrupt, chair pushed back, robe swaying, the action of a man who'd decided that retreat was preferable to continued exposure. "This court is in recess." "Your Honor." Dow's voice, the first time the federal monitor had spoken. Quiet, precise. The voice of a former judge addressing a current one with the careful formality that the bench extends to its own, even when its own has failed. "Before you recess, the department requests that you preserve all electronic records, communications, and surveillance footage in your possession, and direct your staff to do the same. Failure to preserve evidence after notice constitutes spoliation and carries separate penalties." Briggs stopped, halfway between his chair and the door to chambers, his hand on the doorframe, his back to the gallery. He didn't turn around, didn't acknowledge the request, just stood there for 3 seconds. 3 seconds in which every person in the courtroom watched a judge decide whether to comply with a lawful preservation order or walk out and pretend it hadn't been issued. He walked out. The door to chambers closed behind him. The courtroom erupted, not in cheers, not in celebration, but in the low, rolling murmur of people processing something they'd never expected to see inside these walls. Mosser was already on his phone, pressing it to his ear with one hand while gathering files with the other, the scrambling posture of a man who needed to tell someone above him what had just happened and wasn't sure if telling them would help or hurt his own position. In the hallway, through the open courtroom door, Nadine heard footsteps, fast, heavy, gist, running. She heard a stairwell door slam open, the echo of shoes on concrete steps, descending. A moment later, through the courtroom's high windows, she saw him cross the parking lot at a pace that wasn't quite sprinting, but wasn't walking either. He reached his car, fumbled with the keys, dropped them, picked them up, got in. The engine started. He pulled out too fast, tires chirping on the asphalt, and turned left onto the county road heading away from town. Jessup watched from the window, made a note on his legal pad. Then he took out his phone and called the U.S. Attorney's office. The call lasted 40 seconds. "He's running. You might want to track the vehicle." Outside the courtroom, the hallway was chaos. People spilling out, talking over each other, the air electric with the particular energy that follows the puncturing of something that had seemed permanent. Meredith Lyle pushed through the crowd, heading not toward the clerk's window but toward the rear exit, her heels clicking fast on the tile, her phone pressed to her ear, her face white. Scaife hadn't moved. He was still at the security checkpoint downstairs, Nadine learned later, sitting on his stool, phone in his lap, staring at the wall. When a court reporter passed through the checkpoint 20 minutes later, she described him as looking like a man who'd been told something terrible and was still waiting for it to become real. Terrell Boone found Nadine in the hallway. He stood in front of her, tears drying on his face, VFW cap askew from where he'd grabbed it in emotion, right hand shaking, but both arms lifting, hesitating, then wrapping around her in a hug that was brief and fierce, and held the weight of 3 years of fines and warrants, and the cap on the floor, and the dignity that Carver County had taken from him, one hearing at a time. She let him hold on. Then she stepped back, straightened his cap. "It's not over," she said. I know. His voice was rough. But it started. That's more than we had yesterday. Ridley was behind him. The pastor put a hand on Terrell's shoulder, steadying, grounding, the touch of a man who understood that justice feels like relief and grief in equal measure because you can't be glad it arrived without being angry it took so long. Ridley looked at Nadine. Didn't speak, just nodded. The same nod he'd given her every time they'd met. The acknowledgement of a person he'd respected without knowing why, and now knew exactly why, and respected even more for the not knowing. Jessup gathered his materials. Dow made notes on a legal pad. Nadine sat on the hallway bench, the same bench she'd sat on 5 weeks ago, the first morning, with Terrell beside her and the courtroom ahead, and 16 stairs behind, and a device in her pocket recording everything, and rested her hands on the cane, and breathed. The brass plaque on the wall inside, "Reasonable accommodations will be provided," caught the fluorescent light through the open door and gleamed. For the first time in 3 years, someone in Carver County had read it, and someone had done something about it. The Georgia Judicial Qualifications Commission held a preliminary hearing 4 weeks later, December 22nd, a Monday, again. Nadine suspected Jessup chose Mondays deliberately, something about starting weeks with accountability. The hearing took place in Atlanta, at the State Judicial Complex, not Carver County, not Briggs's territory. Neutral ground, or as neutral as ground can be when one side has the evidence and the other side has a union lawyer and a career to protect. The proceedings were administrative, not criminal. The distinction mattered. Administrative hearings determined whether a judge had violated the code of judicial conduct. Criminal charges, if any, would come later, from a different office, through a different process. Justice, as Nadine had learned to accept, moved on parallel tracks that rarely converged at the speed anyone wanted. The panel consisted of 3 JQC commissioners, 2 lawyers, and a lay member. They heard opening statements from DOJ counsel and from Briggs's attorney, a private defense lawyer named Keene Whitmore, who specialized in defending public officials and who charged $450 an hour, paid by the county's liability insurance carrier. Whitmore was good. Nadine gave him that. He didn't deny the evidence, the recordings, the emails, the server logs. He couldn't. Instead, he reframed it. Each violation became an isolated judgment call. Each denial of accommodation became a good faith exercise of judicial discretion. The deleted files became an administrative error by a subordinate employee acting without authorization. Judge Briggs, Whitmore said, addressing the panel with the smooth confidence of a man who'd turned bad facts into acquittals more than once, has served Carver County for 11 years with distinction. His caseload exceeds the state average by 22%. His reversal rate on appeal is among the lowest in the circuit. He is a dedicated public servant who, in the pressures of managing a high-volume docket, may have fallen short of the ADA's requirements, not through malice, but through the systemic resource constraints that affect every small county in this state. Nadine watched from the gallery. She wanted to stand, wanted to hold up her arm and show the panel the marks, faded now to yellow-green shadows, but still there, still visible, still the fingerprints of a man who'd acted under Briggs's authority. She didn't. Jessup presented the evidence. That was enough. The DOJ's case took 6 hours. Testimony from Nadine, 2 hours on the stand, every detail recounted with the precision of someone who'd trained herself to remember grid coordinates and patrol routes, and the exact moment an IED detonated. She described each visit to the courthouse, each denial, each violation. She described the stairs, 16 steps, no rail on the right side, no elevator, no ramp. She described Scaife confiscating her cane and making it clatter to the floor. She described standing for 47 minutes while her knee ground bone against scar tissue, and Briggs told her that asking to sit was contemptible. When she rolled up her sleeve, the bruises were gone, healed, absorbed back into skin that carried other scars from other places where people with authority had decided her body was less important than their convenience. But the photographs were projected on the hearing room screen. 4 purple-black ovals against brown skin, time-stamped, geolocated, undeniable. Whitmore cross-examined her, carefully. He knew he was walking a wire. Challenge a disabled veteran's testimony too aggressively, and the panel would turn against him. Let it stand unchallenged, and the panel would have no reason to doubt it. Ms. Okafor, isn't it true that you entered Carver County Courthouse with the deliberate intention of provoking violations? I entered Carver County Courthouse with the intention of observing whether the courthouse complied with federal disability law. The violations were not provoked. They were ongoing before I arrived, and they continued after I left. You didn't identify yourself as a federal attorney. There was no legal requirement to do so. The ADA applies to all citizens, not only those with federal credentials. But you concealed your identity. I used my real name. I presented my real identification. I filed real complaints using real forms. The only thing I didn't disclose was my employer, because my employer's identity was not relevant to whether a courthouse has a wheelchair ramp. Whitmore paused. He'd expected her to be defensive. She wasn't. She was precise, controlled, the same way she'd been in every interaction in Carver County, absorbing pressure and returning facts. He shifted tactics. The bruises on your arm, you claim they were caused by Mr. Scaife, but you didn't file a police report. Filing a police report with the Carver County Sheriff's Department, the same department that employs officers who use the courthouse daily and work alongside Mr. Scaife, would have compromised the investigation. The injuries were documented through federal channels. So you chose not to use local law enforcement. I chose not to report an assault to the colleagues of the man who committed it. That's not unusual for victims of institutional misconduct. It's one of the reasons the DOJ exists. The panel took notes. Whitmore sat down. Testimony from Terrell Boone followed. He flew to Atlanta on a ticket Ridley's Outreach Center paid for, wearing his VFW cap and the same flannel shirt he always wore, pressed clean for the occasion. His right hand trembled throughout his testimony, but his voice did not. He described 3 years of fines, denials, and the bench warrant issued for a hearing he was never notified about. He described Gist pushing his shoulder and his cap falling to the floor and the deliberate act of stepping over it. He didn't pick it up, Terrell said. He stepped over it, over a veteran's cap, on the floor, and he kept walking. The lay member of the panel, a retired schoolteacher from Savannah named Georgine Holt, removed her glasses and pressed 2 fingers against the bridge of her nose. She didn't speak. She didn't need to. Testimony from Diana Chow came next. She walked the panel through the server logs line by line, timestamp by timestamp, deletion by deletion. 3 files. 6 minutes. 1:42 in the morning. Then Claudette Marsh. Video link. Carver County. 73 years old, in her wheelchair, with her oxygen tube and her Marine Corps pin on the collar of a blouse she'd ironed that morning, despite the pain it caused her arthritic hands. Her opening statement consisted of 4 words that landed in the hearing room like artillery. I couldn't get in. 4 words. 35 years of military service. And a courthouse that wouldn't let her through the door. Briggs sat in the gallery throughout the proceedings. Suit and tie, no robe, seated beside Whitmore with the rigid posture of a man holding himself together through force of will. He didn't testify. Whitmore had advised against it, and Briggs, for once, had listened to someone else's counsel. But his face told its own story. With each piece of evidence, each testimony, each photograph projected on the screen, something behind his eyes contracted. The slow, involuntary withdrawal of a man watching his legacy be disassembled in front of people he'd spent 11 years teaching to fear him. When Claudette Marsh said, I couldn't get in, Briggs looked down at the table. His fingers interlaced, his thumbs pressed together hard enough to whiten the nail beds. He didn't look up again until the hearing recessed for the day. The panel deliberated for 3 days. The decision came the following Monday, January 5th, 2026. A cold day. Nadine read it in the field office, alone, at 7:32 a.m. Jessup had emailed it overnight. Findings and interim order. Georgia Judicial Qualifications Commission, case number JQC-2025-0189, regarding Judge Caldwell Briggs. The Commission finds sufficient evidence to proceed with a formal investigation into violations of the Georgia Code of Judicial Conduct, Canon 2, Appearance of Impropriety, and Canon 3, Performance of Duties. Judge Briggs is suspended with pay pending the completion of the investigation. He is prohibited from presiding over cases, entering courtrooms in an official capacity, or contacting witnesses in the underlying federal compliance review. Suspended with pay. Not removed. Not disbarred. Suspended with pay. The institutional equivalent of a timeout, complete with continued salary, during which a judge who denied disabled veterans the right to sit in his courtroom would sit at home and collect his paycheck while lawyers argued about whether what he'd done was bad enough to end his career. Nadine read it again. Then she read the rest. Regarding Rowan Scaife, terminated, effective immediately. Violation of county employment policies including unlawful seizure of personal property, battery on a member of the public, destruction or concealment of a complainant's personal records, the notebook, and failure to follow ADA accommodation protocols. The county waived Scaife's right to a grievance hearing as part of a separation agreement that included a non-disclosure clause and 60 days of severance. A non-disclosure clause. Even in firing him, they'd made sure he couldn't talk about what he'd done, or more importantly, who'd told him to do it. Regarding Nolan Gist, suspended without pay for 90 days. Pending criminal referral to the U.S. Attorney for the Middle District of Georgia for potential charges under 18 U.S.C. Section 1519, Destruction of Records. The county's position was that Gist had acted independently and without authorization, despite the email from Meredith Lyle directing him to handle it after hours and providing the admin login. Gist had lawyered up immediately, union counsel. The Police Benevolent Association, despite Gist not being a police officer, he was a court bailiff, had agreed to fund his defense as a professional courtesy, the legal system protecting its own. Regarding ADA, Clint Mosser, written reprimand for procedural errors in the citation of cross-jurisdictional precedent. No suspension, no fine, no referral. The reprimand would be placed in his personnel file and reviewed at his next annual evaluation, which was 11 months away, by which time the file would be a footnote and the evaluation would focus on case outcomes and conviction rates, and all the metrics that mattered to a prosecutor's office, and none of the metrics that mattered to the people Mosser had helped punish. Regarding Meredith Lyle, administrative reassignment to the county's Records Management Division. Not terminated, not disciplined. Reassigned, moved from the clerk's window where she'd controlled access to the courthouse and its complaint system to a back office where she'd control access to archived documents and filing cabinets. The county described it as a lateral move reflecting organizational needs. Lateral. The word tasted like something rotten. Nadine set down the decision, looked at the wall. The timeline was still there. 34 months of data points, each one a person, each person a story of being denied and dismissed and erased by a system that had never been designed to include them. Partial victories. That's what Jessup had warned her about back in the first week, when she'd sat in this same chair and asked what realistic outcomes looked like. 1, maybe 2 people held accountable, he'd said. Policy changes announced but enforcement uncertain. An investigation that continues for months or years. And the system. The actual system, the culture, the assumptions, the invisible architecture of who matters and who doesn't. That changes last. If it changes at all. She'd accepted it then. She accepted it now. But accepting it didn't make it hurt less. She called Jessup. He answered on the first ring. He'd been waiting, knowing she'd read it, knowing she'd need to talk. "It's not enough," she said. "It's never enough. That's the job." Mosser cited fake precedent to double a disabled veteran's fine. He gets a written reprimand. And the reprimand creates a paper trail. Next time he does it, and there will be a next time, the pattern is established. First offense is a warning. Second offense has consequences. The system is slow, Nadine, but it remembers, if we make it remember. She was quiet. Lyle directed the deletion of federal records. She provided the admin credentials. She's the one who put my complaint in the general correspondence tray instead of the ADA tracking system. And she gets a lateral transfer. The county is protecting itself. If they terminate Lyle, she testifies against them, against Briggs, against the county administrator, against whoever sent that redacted email. They'd rather keep her quiet and employed than fired and angry. It's ugly. It's also predictable. It's obstruction. Arguably. And we'll argue it. The U.S. attorney has the email chain. They're convening a grand jury in March. Lyle will either cooperate or she won't. And if she won't, the emails speak for themselves. Nadine closed her eyes. The field office was quiet. The server rack hummed. Outside, a cardinal was singing in the Bradford pear tree, insistent, repetitive, the same four-note phrase over and over, like a bird that believed persistence would eventually be heard. Raymond. Yeah. Claudette Marsh served 35 years. She received a Bronze Star. She has a condition that requires supplemental oxygen, and she couldn't attend her own hearing because a bailiff shrugged at her and offered to carry her down 4 steps like she was luggage. I know. That should be worth more than a plywood ramp and a suspended judge. It should, and one day it might be. But today, it's worth a compliance review, a consent decree, a federal monitor, and the knowledge that the next wheelchair user who approaches those steps will find a ramp instead of a shrug. That's not everything, but it's not nothing. She didn't respond for a long time. Then, I'm going home after this. To Atlanta. I need to see my mother. I need to open a letter from the VA that I've been carrying for 6 weeks. Take the time. The consent decree negotiations will take months. The investigation will take longer. This fight will be here when you come back. That's the problem, Raymond. The fight is always here when we come back. She hung up, sat in the chair, looked at the timeline on the wall one more time. Every data point a person. Every person a story that deserved better than a preliminary finding and a pending investigation. Then she stood, picked up her cane, and began packing the field office. The case files went into boxes. The timeline came off the wall, rolled carefully, secured with rubber bands. Diana's server rack would stay. The data lived there, backed up to 3 locations, encrypted, preserved against the possibility that someone in Carver County would try to erase this evidence the way they'd erased the complaints. Some things, once documented, couldn't be undocumented. That was the only real victory in a system designed to forget. 2 months later. February. The ramp went up. Not a real ramp. Not the permanent, ADA-compliant concrete and steel structure that the DOJ's consent decree would eventually require. A temporary ramp. Wooden. Plywood surface, 2x4 railings, a slope that was slightly too steep, and a landing that was slightly too narrow. It was bolted to the side of the courthouse like an afterthought, which was exactly what it was. But it was there. A woman in a wheelchair could use it to enter the building. A man with a cane could use it to avoid the 7 stone steps. A veteran with a titanium hip could use it to reach the courtroom where a new judge, Judge Corinne Whitfield, appointed interim by the chief judge of the Superior Court, would ask if he needed a chair before he needed to ask for one. Terrell Boone's fines were vacated. All of them. Judge Whitfield reviewed the case file, noted the absence of proper rescheduling notification, and dismissed the bench warrant, the contempt finding, and the accumulated penalties in a single order that took 4 minutes. 4 minutes to undo what 3 years of Carver County's system had built. Deshaun Niles received a written apology from the county administrator's office. 1 paragraph. Official letterhead. No admission of wrongdoing. The word regret appeared twice. The word apologize appeared once. The word systemic appeared 0 times. Arturo Reyes's wife got her interpreter. For every future hearing. Court-funded. Mandatory. Curtis Vega was told he could bring his service dog to any county facility without restriction. The policy was posted at the entrance. Whether Vega would ever trust the courthouse enough to return was another question. Ranger still flinched at loud voices. Claudette Marsh, the Marine, the wheelchair, the oxygen tube, called Nadine on a Tuesday evening in late February. The conversation was short. "I heard about the ramp." "It's temporary. The permanent one is part of the consent decree, but the county hasn't signed yet." "Temporary is still more than we had." A pause. Then, quieter. "Thank you, Ms. Okafor, for seeing us." The line went quiet. Nadine held the phone against her ear and listened to the silence. The silence of a 73-year-old woman who'd served her country and been denied entry to her own courthouse and had called to say thank you for a plywood ramp that wobbled in the wind. "Sergeant Marsh," Nadine said, "it should never have taken this long." "No, it shouldn't have, but it did. And you came anyway." The consent decree remained unsigned. The county's outside counsel, a firm from Atlanta that charged rates Carver County couldn't afford, but paid anyway from a liability insurance policy that was designed for exactly this kind of institutional failure, argued that the DOJ's requirements were overly prescriptive and financially burdensome for a county of limited resources. They counterproposed a voluntary compliance plan that included installing the permanent ramp by 2027, hiring an ADA coordinator by 2028, and implementing staff training as resources allow. Jessup rejected the counterproposal in a 3-page letter that Nadine proofread. The letter cited 12 federal cases in which courts had found similar voluntary compliance proposals inadequate. It also noted that Carver County had spent $340,000 on outside legal fees fighting the consent decree, enough to build 4 wheelchair ramps, install 2 elevators, and fund an ADA coordinator's salary for 3 years. The negotiations continued. They would continue for months, maybe longer. The system protected itself the way it always did, not through direct refusal, but through delay, through complexity, through the exhausting, grinding machinery of legal process that turned urgency into procedure, and procedure into waiting, and waiting into acceptance that change would come eventually, just not today. The email remained unexplained. Nadine had flagged it in her initial evidence review. A message recovered from the server backup dated June 2025, 4 months before she'd arrived in Carver County. Sender: recipient c.briggs@carvercounty.gov. Most of the content had been redacted by county counsel under attorney-client privilege, a claim DOJ was challenging in a separate motion. But one line survived the redaction. "The federal inquiry can be delayed if we reclassify the complaints as constituent correspondence rather than ADA filings." Someone whose name the county was spending significant legal resources to protect, had known about the DOJ's interest in Carver County before Nadine arrived. Someone had advised Briggs on how to hide the evidence. Someone had provided the strategy that Meredith Lyle had executed and Nolan Gist had implemented at 1:42 in the morning. That someone's identity remained hidden behind a redaction bar and a privilege claim and a legal battle that would play out over months in a federal magistrate's chambers, while the person who'd orchestrated the cover-up continued to operate, unnamed and unaccountable. Nadine thought about that email every night. She thought about it the way she thought about the 10 minutes of missing body cam footage. Gist's camera, November 3rd, the day she'd been forced to walk 60 meters without her cane while Scaife and Gist watched. The audio had survived. Shuffling steps, labored breathing, the scrape of her palm against the corridor wall, and one sound, brief, quiet, unmistakable, the sound of someone laughing. The video was gone. Overwritten. FBI analysis confirmed the deletion was deliberate. The file had been accessed and scrubbed using the same admin credentials Gist had used for the complaint files. But without the video, there was no visual evidence of what had happened in that hallway. Just audio. Just the sound of a disabled veteran being humiliated by 2 men in uniform, recorded by a device they didn't know existed, preserved on a server they didn't know backed up. Partial evidence, partial justice, partial victories. The pattern. Nadine packed her bag at the Pinecrest Motor Lodge on a Thursday morning in early March. Same routine, shoes aligned, cane on the right side, items checked in sequence. The room was the same as the day she'd arrived. Thin walls, rattling window unit, sagging mattress. On the nightstand, 2 items. The first, a text message from Pastor Ridley, received 3 days ago, unanswered. Ms. Okafor, the community wants to thank you properly. Will you come to Sunday service? There are people who'd like to meet you. People you helped without ever meeting them. She'd read it 4 times, hadn't responded. The invitation was genuine. The warmth behind it was real. But Nadine Okafor was not a person who accepted thanks easily. Not because she didn't value it, but because accepting thanks meant accepting that the work was finished, and the work was not finished. The consent decree was unsigned. The redacted email was unresolved. The system was dented but not broken. And the plywood ramp outside the courthouse creaked in the wind like a promise that could be revoked at any time by anyone with a wrench and a reason. The second, the letter from the VA Medical Center, still unopened. The envelope was creased now, softened by weeks of being picked up, turned over, set down, picked up again. The return address read, Atlanta FIV Medical Center, Orthopedic Surgery Division. She knew what was inside. She'd requested the evaluation 8 months ago, a reassessment of her knee, an updated surgical recommendation, a determination of whether the joint had deteriorated enough to warrant the replacement she'd been postponing since 2019. The answer was almost certainly yes. The knee was worse. It was always worse. Every staircase in Carver County had made it worse. Every step without the cane had made it worse. Every morning she'd climbed 16 stairs to a courtroom that should have had an elevator, had accelerated the damage by months. She'd sacrificed her knee for this case. Not dramatically, not in a single moment of crisis, but incrementally, step by step, stair by stair. The slow accumulation of damage that happens when a person uses their body as a tool and doesn't stop using it when the tool starts breaking. She picked up the letter, held it, felt the weight of it. Light, barely an ounce, but heavy with the knowledge of what it contained and what it would require. She put it in her bag, unopened. She would open it in Atlanta, in her own apartment, with a cup of tea and a chair that didn't wobble, and a door that locked with a deadbolt she trusted. Some things you opened when you were ready, and some things you opened when you were home. She drove past the courthouse on her way out of town. The plywood ramp was visible from the road, raw wood, unpainted, listing slightly to the left where the foundation bolts had loosened in the February rain. A small orange cone sat at the top, marking a section where the surface had splintered. Above the ramp, on the second floor, a window was dark. Briggs's chambers. Empty since January 5th, the desk cleared, the files boxed, the nameplate removed and placed in a county storage facility alongside the nameplates of 4 other judges who'd been suspended in the past 20 years, and 2 who'd been removed entirely. Whether Briggs would join the latter group was a question the JQC would answer in the coming months. The investigation was ongoing. Witnesses were being deposed. Records were being subpoenaed. The process would take as long as it took, which was both the strength and the weakness of a system designed to be thorough at the expense of being timely. In the parking lot, the 2 disability spaces were empty. No white F-150, no silver Dodge. New signs had been posted. Larger, with reflective paint, visible from the road. Reserved. Disability access only. Violators subject to fine and towing. Whether anyone would enforce the signs was another question. Signs were easy. Enforcement required will, and will required the kind of sustained, exhausting, unglamorous attention that most institutions abandoned the moment the cameras turned off and the federal monitors went home. Nadine slowed the car, looked at the courthouse one last time, the white columns, the Georgian brick, the flag snapping in the March wind, the plywood ramp bolted to the side like a bandage on a wound that went deeper than anyone wanted to admit. Her phone buzzed. Unknown number. 843 area code, South Carolina. She let it ring twice. Then she answered. The voice on the other end was the same as the one from the missed call weeks ago. Male, middle-aged, controlled. but this time it spoke clearly. Counselor Okafor. My name is Paul Embry. I'm a reporter with the Charleston Post and Courier. I've been investigating judicial misconduct in Georgia's rural court systems for 2 years. I have the email you've been looking for, the unredacted version. The sender is someone you'll want to know about. She pulled the car to the shoulder, turned off the engine. I'm listening. Not on the phone, in person. I have documents. I have sources. And I have a name that connects Carver County to 3 other courthouses with identical ADA violation patterns. This isn't one judge, counselor. This is a network. The words settled into the silence of the car, like a stone dropped into still water. Network. Not one courthouse with one biased judge and one broken elevator. A network. Coordinated, deliberate, replicated across county lines like a franchise of institutional cruelty. How did you get my number? Public record. Your name was on the DOJ compliance review filing. I've been watching Carver County for 8 months. When the review was announced, I recognized the pattern. Same playbook I've seen in Macon, in Valdosta, in a county I can't name yet because the source is still inside. What playbook? Reclassify ADA complaints as general correspondence. Delay elevator repairs indefinitely. Use contempt findings to punish people who can't stand. Delete records after hours using shared admin credentials. The language in Meredith Lyle's email, same as last quarter, don't log them in the federal system. I've seen nearly identical phrasing in internal emails from 2 other court administrators in 2 other counties. Word for word, counselor. That's not coincidence. That's a template. A template. Someone had written a playbook for violating the ADA and distributed it across Georgia's rural courthouses. Someone had designed a system for making disabled people disappear from the complaint process, not through violence, not through dramatic acts of evil, but through bureaucratic reclassification and digital deletion and the quiet, grinding, invisible machinery of institutional indifference. The redacted email, Nadine said. The one from June 2025. I have it. Unredacted. The sender is a former state judicial administrator who now works as a private consultant. He sells compliance management strategies to small counties that can't afford full-time ADA coordinators. What he's actually selling is a system for evading federal oversight. $50,000 a year per county. 4 counties that I know of. Possibly more. Nadine closed her eyes. The knee pulsed. The March wind rocked the car gently back and forth, like a cradle for something newborn and fragile. Friday, she said. Atlanta. Send the coordinates. I'll be there, counselor, and bring your recorder. The line went dead. Nadine looked through the windshield at the courthouse growing smaller in her mirror. The plywood ramp, the empty parking spaces, the dark window on the 2nd floor. 1 courthouse, 1 ramp, 1 suspended judge. 1 partial victory in a system that ran on partial victories because total victories required the kind of resources, attention, and political will that nobody maintained long enough to see them through. And now a reporter was telling her there were 3 more courthouses, 3 more judges, 3 more sets of disabled veterans being denied the right to sit in a room where their fines were doubled and their complaints were deleted, and their dignity was treated as an inconvenience. She closed her eyes, felt the knee, the constant low-grade burn that had been her companion for 11 years, worse now, always worse, the cost of the work written in cartilage and scar tissue. When and where, she said. Atlanta, Friday. I'll send coordinates. The line went dead. Nadine sat in the silence. The March wind buffeted the car. In her bag, the VA letter waited. On her phone, the pastor's invitation waited. In Atlanta, a reporter with documents waited. And in Carver County, the plywood ramp creaked in the wind. Temporary, imperfect, already splintering. But there. Present. Functional. A thing that had not existed 5 weeks ago, and now did, because a woman with a cane and a recording device and a 70% disability rating had climbed 72 flights of stairs she shouldn't have had to climb, stood in a courtroom that had no chair for her and refused to stop until someone listened. She started the engine, checked the mirror. The courthouse was gone, around a bend, behind the Bradford pear trees that had lost their leaves in October and wouldn't bloom again until April. But the ramp was still there, and Nadine Okafor was still fighting. She pulled onto Route 9, headed east, toward Atlanta, toward the VA letter, toward the reporter, toward the 3 courthouses she didn't know yet but already understood, toward the long and exhausting and incomplete and necessary work of making systems answer for the people they were built to serve. The road stretched ahead, empty, straight, long. She drove. End of Part 2. Every day in America, disabled veterans walk into public buildings that were designed without them in mind. They climb stairs that should have ramps. They stand in courtrooms that should have chairs. They file complaints that disappear into filing cabinets labeled general correspondence and never reach the people who have the power to act. They are told that equal treatment means identical treatment, a lie that ignores the reality of bodies shaped by service and sacrifice, bodies that gave pieces of themselves so that the rest of us could live in a country where the law promises accommodation and the practice often delivers indifference. Nadine Okafor's story is fictional. The patterns it describes are not. The Department of Justice has filed ADA compliance actions against courthouses, jails, police departments, and government buildings across the country. And in almost every case, the violations were known for years before anyone with authority chose to act. The gap between the law on the wall and the law in practice is filled with real people, veterans, elderly citizens, individuals with disabilities, who are denied access to the institutions that are supposed to serve them. You do not need to be a federal attorney to change this. You need to notice. You need to document. You need to ask the question that nobody in Carver County asked until Nadine arrived. Why is this building not accessible, and who decided that was acceptable? If you see a public building without a ramp, report it. If you witness someone denied a reasonable accommodation, record it. If you know a veteran who has been fined, penalized, or held in contempt for the act of being disabled in a space that refuses to accommodate them, help them find the resources to fight back. The ADA is not a suggestion. It is the law, and it only works when people insist that it be followed, not eventually, not when the budget allows, not after renovation. Now, notice, document, act. Because every ramp that exists today was built because someone refused to accept the stairs.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.